listed. Transfer petition methods, otherwise transfer method, I'm telling you transfer method. Tomorrow, my lord, otherwise movement order will be issued any moment. Friday. Right. All right.
These two matters are pending matter, Malo. Since the February year, they have not listed, Malo. Non-payment of salary, Malo. Can it be on 15th, Malo?
My lord, I have also similar prayer matter, pension matters.
Item number 48 of today's. Number 48 of today's list, Malad. With consent of the other party, Malad, I beg to mention for today, Malad. Can it be on Wednesday next, Malad, 17, Malad?
Your Honor, I am for the item number 48, your respondent side, Your Honor, for the health department, Your Honor. We have a DP Bora, Your Honor. We have filed IA, Your Honor. So the IA along with the W rate petition is.
Yes, this is another IA matter. They also filed an IA. Yes, ma'am.
Yes. Along with the, Your Honor.
17. Yeah. Interim order is there, ma'am. Obliged.
Please, so item number 22. The respondent has filed an additional affidavit yesterday, so it may be taken up next Wednesday, 22. Will file reply to their additional affidavit. No, Lordship, there is urgency. They are going to recruit the fresh recruitment, Lordship.
17.
Okay. And there is also a prayer for listing of an urgent declaration, Lordship, for regarding compulsory retirement. So it may be also taken up next week.
Lordship, with the consent of the other side, I beg to mention item number 25 in Lordship. This is for the respondents. This matter may come up after vacation.
Let's go.
May please, Lordship, I beg to mention for listing of the petition. It was last listed on August 2025, Lord. Matter pertains to termination of service. Can it be before vacation, Lord? Matter pertains to the termination from service, Lord. Kindly, Lordship, before vacation. Obliged.
For listing on suspension. Yes, ma'am. Before the vacation.
May please, Lordship. Lordship, I beg to mention for listing on content matter, may I pray on 19, my lord of you. His pension matter, my lord, petitioner is not getting pension, family pension since 2022, my lord. His, my lord, he is not getting since 2022. 22, not a single penny. A lady, my husband died. I am deeply.
Item number 20 may come after vacation.
Item 21, so certain affidavit was to be filed, bringing on record initial orders of appointment.
I beg to mention item number 8, Lordship. Item number 8, Lordship, with a concern of other side, Lordship. Kindly matter will be urgent for a day, Lordship.
Please, Lordship, one affidavit was filed yesterday, Lordship. Kindly call for that affidavit. Item number 26, Lordship, as per direction of this court, Lordship. 26. Lordship. Please, Lordship, I beg to mention for a listing of a WBC matter. Lordship, that was lastly listed on 23/9/2020. Lordship, may kindly fix it. 22.
May I please, Lordship? Lordship, I beg to mention an item for. Lordship, I beg to mention an item for listing for orders.
May I please, Lordship? I beg to mention for listing of admission matter. It is a non-payment of medical reimbursement.
May it please, Your Lordship, I beg to mention item number 31. Here we have filed an affidavit as an reply. So matter may be taken on 17th of June, Lordship. Yes.
May it please, Your Lordship. Lordship, with regard to item number 35, I have instructions to withdraw the matter.
Please, Your Lordship. I beg to mention item 36. Matter become infractions.
May I please, Lordship? I pray for listing a motion matter on Friday, Lordship. Lordship, matters regarding selection and appointment. Yes, on 8, Lordship. 8. No, Lordship. Yes, Lordship. Oblige, Lordship.
Lordship, I want to mention regarding listing of the petition for admission, Lordship. Matter relates to termination of service petition. Oblige, Lordship. I love this content petition, my lord, for violation of interim order, my lord. My lord, writ petition was last listed on 2nd, my lord, 2nd of June, and status quo was extended up to till the next date, my lord. But we have informed the honorable court, my lord. We have already informed on 2nd of June, my lord, regarding the non-compliance, my lord. Verbally, my lord, we made submission.
Page 9, my lord, annexure 1, my lord, relevant page 14.
Mr. Gogoi was supposed, yes.
Regarding that document. Yes, it is a page number 131. There it has been mentioned regarding only 57 employees. So apprehension of the petitioners herein is that, my lord, by this letter we are seeking, my lord, documents of only 57, my lord, casual worker or, my lord, contractual workers for granting a minimum of pay scale. Now, lordship will see in the third para. In view of the above, all the joint directors etc. are hereby requested to submit the pending documents in respect of the remaining employees. Not only limited to this 57.
So
but
all are included.
all are included. But so far
Let
as
them file a small
yes,
affidavit.
that affidavit will be necessary. And more so, my lord, here, so far as the petitioners are concerned, lordship will see page 32. One or two documents I will place. 32, lordship will see the second line, my lord, second para. The Hospital Management Society reserves the right. So, my lord, not engaged by the government as such.
by any authority under the government. Is the society registered under the Society Registration Act? On their own, my lord, they generate revenue from the hospital, my lord, those from the patients. And on the basis of that, my lord, whatever remuneration is paid, my lord, is paid from that, my lord.
So, but
How come you have called for 57 similar?
No, I'm not-
57 will be also similarly situated.
Yes.
No, cannot be, my lord. That will be verified by the government. But so far as this, my lord, apparently it appears, my lord, I am pointing out that, my lord, they have been engaged by the management society. In fact, in one or two cases, my lord, where there was a direction that they will submit individual applications, my lord, and it will be verified. Government has rejected that claim. So I will file one short affidavit before vacation, lordship will fix it. Let me, my lord, please.
Well, our only concern is that our cases should be considered.
Fine,
Milord,
I will
Hospital
file an
Management Society, though it is registered as a society, but it is the superintendent of the hospital who is the main man there. End of the day, my lord, we are rendering service to a government hospital. Well, let us not play with all these expressions. End of the day, it's a welfare state. You have to take a position which is not. You can't take a position oblivious of what the Constitution
society
says.
can pay, my lord. We are not on that. If they agree, they can pay this up to them.
No,
Even
that
more
can't
than
be an
what they are
argument, my
paying,
lord.
lord.
That can't be an
my
argument.
lord, yes, I will
Basically,
find
we
out
are
from the-
employed by the state.
If in similar cases, it has been rejected.
Management society, then who are the officials of the
Exactly.
Not
management
even,
society?
there are certain guidelines, my lord, where on the basis of which, my lord, they will have to run the society. There it is categorically mentioned that you can engage employees, but, my lord, you will have to
Societies
bear
are running what hospitals?
government hospitals, my lord.
Government
So far as the revenue is concerned, my lord, like the patients are admitted, minimum fee is paid. Some, my lord, say, my lord, the X-ray is done, CT scan is done. That is, my lord, kept by the revenue, by the management society to run the hospital.
Government hospitals are supposed to provide free, more or less.
No, no,
5 rupees for registration.
yes. So some is there, my lord, some features are
5
there.
rupees for registration.
No, 5 or
At
50.
subsidized rate, my lord, 5 rupees. And my lord, subsidized rate.
I will place
See,
it, my lord.
after so many judgments of the apex court, this line today, I think
But
there is a time for revisiting this earlier concept of
Yes.
having a specific order, sanction post. You are expecting service of a person, that too in a government hospital. And then you throw them away saying that 5 rupees, 10 rupees, 15 rupees, whatever is collected, you pay the salary. How is it possible? How will they render service?
End of the day, my lord,
Given
these
by the
people are
government,
required to
will be
run the
affected.
hospital.
Who will be affected? Citizens who are having access to that.
in the meantime, my lord,
Tomorrow you may take a decision that all right, all petitions, you go and engage your private nurses and bring them with you. Possible. All right, you file your
we will
affidavit.
file a affidavit.
We'll keep it on
Before vacation.
Yes, sir.
17th or
Yes.
17th,
So, lordship,
19th.
yes, 19.
The only thing is that letter speaks of 10th of June. That part, my lord.
So that lordship can, well, lordship will pass an order when the if at all they are entitled. Then it can be always, we have to be
19th
complied with.
Lordship will kindly make an observation that this aspect will be considered on that day.
Heard Mr. K. Chaudhary's counsel. Mr. Gogoi in instruction submits that there are some furnished with some instructions. We'd like to bring it on record. And he seeks liberty to file an affidavit. Mr. Chaudhary, on the other hand, expresses apprehension that by the communication dated 13/3/26, where is that 10th of June?
Lord, page 141.
By the communication 26/5/2026, the required documents to be submitted by the joint directors is fixed on, the last date is fixed on 10th of June 26. He therefore submits that if required, the court will examine the matter and pass appropriate orders, notwithstanding the deadline being fixed on 10th of June. Having heard the counsel for the party, let this matter be listed as agreed to on 19th.
Miller.
And by which date the respondents will file their affidavit. You file it by 17th.
19th, I have some difficulty, Milord. Lordship, may I kindly have it on Lord 22 or 23, Milord?
22.
Yes.
And the
By
respondents.
19th, I will file my affidavit.
18. 18, they will, by the respondent will file their affidavit by 18th of October. While the court required, the department may proceed with the the verification of the documents, which however will be subject to further orders from this court. Extra copies, if not served, please serve.
The petitioners was appointed on a compassionate ground in 1995. Thereafter, but on work charge basis, wrongfully. Thereafter, she was regularized in 2022 pursuant to a High Court's order. See at page 25 for once. 26 is the High Court's order. 27 is my regulation order. Last line. From the date of her initial appointment, pursuant to which all the benefits were given. However, the notional seniority was not given. I approached the authorities regarding giving me the notional seniority at page 40. Now the authorities has rejected my prayer.
You should notice what else.
Lordship, in this connection, on similar facts, the law has been settled by coordinate bench. At page 41, operative part, he was also appointed on compassionate ground on work charge basis. Later on, he was not regularized. He came to the court. He was granted regularization along with this observation at page 48, Lordship. Second paragraph. The period of service rendered by the petitioner with effect from so and so shall be reckoned for the purpose of fixation of seniority on being adjusted against a post in regular and shall also be reckoned for the purpose of computation of pension.
Who's for the PWD?
Lordship, I am appearing. Lordship, notice me the issue at this point will also obtain the instructions.
He is submitting that he's praying for similar orders at page 42.
Lordship, but at
Lordship,
page,
I'll pray that let them take the instruction whether it is similar or not.
Lordship,
List it from
Third counsel for parties, the respondents will obtain instructions as to whether where the petitioner is similarly situated by the petitioner in WPC 4585 of 2023, Nature 14. Therefore, title and his claims are required to be considered in terms of such orders being passed by the court bench. MSA Board of Learned Counsel appearing for the PWD and Finance will obtain instructions in the matter. This matter again on 19th April.
highly honored.
Your Lordship, kindly see page 27, 26, 27. This is after he worked since 1984. 1989, got this promotion. Selection committee has selected various posts are there. Petitioners is at below, my lord. Promotion to section assistant. Committee observed that out of total 15 posts. Also, ultimately, page 27 and the petitioner name is at serial number 11. So they have decided to promote him to the post of section assistant. And the page, since they did not do it, we came before this court. Court directed that you take an action. They did not do it, we filed a contempt petition. Then thereafter they have approved it. Now they are saying, my lord, paragraph page 39. But others have been promoted on the basis of 2017 decision. Page 39, they are saying that no date is given. So how can we do it? In the meantime, petitioner has already done. I am seeking my lord similar benefit which has been given. to others.
Not I.
Let them produce the records relating to the promotion of others.
Let them get the instructions. I think we'll have to issue notice here.
RPF all the respondents.
But in the meantime, my lord, their pension is provisional pension will be paid. Because he has retired from service.
Heard Mr. B. D. Das.
December 25.
Senior counsel, requested by Mr. Richard Us. Mr.
S. Sharma.
S. Sharma. Yes, for all the respondents.
Yes, madam.
Petitioner submits. Petitioner's claim before the court is motion promotion to the post of sectional assistant,
Section.
which according to the petition, not granted to the petitioner during his period of service. So, he has since superannuated
On 31/12/20.
on 31/12/25.
Others have been my lord promoted on the basis of the selection committee.
The petitioner's claim is that similarly situated persons have been considered for promotion and effective orders were issued. However, in case of the petitioner, such promotion orders were not issued. Meanwhile, in superannuated service, the respondents complete their instructions and file necessary affidavit if so advised. Meanwhile, pendency of the petition will not be a bar to release the provisional pension in respect of the petition.
So it will come after vacation.
4 weeks.
Like,
Please, your lordship.
Mm.
My lord, the dispute is related to the my lord quantum of pension.
These are all matters pending. You are supposed to file affidavit.
Affidavit has been filed, but date has not been fixed. Two matters are fixed together. Two matters have been fixed together, but date has not been fixed.
All right, issue notice. Heard counsel will party issue notice. Return over 4 weeks. Respondents being represented by Mr. A. Ghosh and Mr. Chakraborty is there.
respondent number 5 blocks.
Respondent 5. Mr. Ghosh appears for 1,
4,
4,
6,
6, 1, 4, 6. Mr. Chakraborty for and 5. MS for Thakur for 3 and 7. So the respondents are represented. If extra copies be furnished within a period of 1 week, matter be listed
so it may maybe tagged.
On 1st of August to be listed along with WPC
1121 of 26.
1121 of 26 in the matter where you filed affidavit.
There are two matters. We have filed one.
Give the number of those matters
839 of 26.
and 839 of 26. Please take note.
Highly obliged.
matter, but it's for the pension matter. Yeah, well, date matter I have only mentioned in the paragraph 3 matter. Date of joining and date of discharge matter. Otherwise, the matter is correct matter. Now, date of joining is on 24 on 1970 matter and discharge from service on 7 to 1999. After serving for 20 years matter. The petitioner got married with her husband matter after the date of first word matter. And petitioner husband died on matter 1st of October 2020 matter. And come to page 23 matter. The petitioner matter has approached the welfare officer matter. Welfare officer. And subsequently he had forwarded the application matter the record officer matter. For including the name of the petitioner as the widow of the year. But no action matter so far is taken matter. It was forwarded on 5 January 2021.
You are seeking a direction against whom?
And to the records officer, my lord. For including the name of the petitioner, so as to, my lord, he can get the family pension. Page 23, my lord.
Three.
The application, my lord. Letter was given to the
Any instructions? Third council for parties issue notice, letter number 4.
Sharma, I'm for respondent number
LD,
NN.
ND Sharma. Appears for all the respondents,
Respondent number 1 to 5.
1 to 5.
Yes.
What about 6? 6,
army personnel, retired army personnel. So we can
steps on respondent 6, 7, 8 by speed post within 1 week window. That will be listed after the return.
my lord, I may be able to rectify the mistake, my lord.
Presence of the court master.
Right. Okay.
Yes. Canara Bank.
Yes, my lord.
Canara Bank doesn't lay down any law
My lord,
as on date.
law has been laid down. This is the
How? It has been
final
referred to
judgment.
larger
Your
bench.
lordship may kindly see the last page.
Last page.
Yes, this is the final judgment now.
How is it a final judgment?
And here, my lord, some precedents have been laid down, my lord. These are very much in force. Page, my lord, page 73, my lord. Start from page 73. Judicial precedents on the issue of compulsory settlement. Some precedents.
What is the
have been laid
discussion
down.
regarding Devabrat Tiwari?
There's no mention about Devabrat
Then
Tiwari.
that is the problem.
But here, my lord, regarding delay, my lord, page 20, para 27, your lordship may kindly produce para, page 77 at the bottom, my lord. Devabrat Tiwari is of 2023 and this is of 2025, decided on 11/2/2025. And here regarding lapse of time, my lord, page 77, para 27, my lord. Lapse of time could, however, be a major factor for denying compassionate appointment where the claim is lodged belatedly. A presumption is legitimately laid in cases of claims lodged belatedly that the family of the deceased incapacitated employee is not in immediate need of financial assistance. However, what would be a reasonable time would largely depend on the policy scheme for compassionate appointment under consideration. If any time limit has been prescribed for making an application and the claimant applies within such period, lapse of time cannot be assigned as a ground for rejection. So, my lord, here the petitioner's father died on 4/12/2013 and the petitioner applied on 17/5/2014. Within 1 year, my lord. Very much in time, my lord. And we pursued the matter.
According to you, the delay occurred in the hands of the respondents.
Delay is due to the, my lord.
To the respondents.
Dear Lordship, on right on 2013, Lordship, it is approached before the court, Lordship, 2026, Lordship.
But the
13 years
matter was,
lapsed there,
All right.
Lordship.
the petitioner
And Lordship,
pursued the matter, my
she
lord.
was survived, Lordship, at
Right.
that time, Lordship.
Third council for parties issue notice return.
1, 2, 4, and 8, Lordship.
1, 2,
4 and 8.
4, and 8. Mr. J. Handy, please responding number
3, 5,
3, 5,
and 9.
6 also.
6. 3, 5, 6, and 9.
3, 5, 6, and 9. What about 7? State government.
7.
Mr. Chakraborty will appear for
7, Lordship. 7 also, Lordship.
1,
7.
1, 2,
1,
Then
2,
4,
4, 7, and 8, Lordship.
1, 2, 4,
7 and 8, Lordship.
7, 8.
And 8.
Mr. J. Handy for 3,
3, 5, 6, and 9.
5, 6, and 9. The respondent, the representative, notices of waiver, extra copy of the furnished is included. This matter after the written complaint.
My lord, item 49 is similar, my lord.
Same 49. Okay, doctor. Yes.
May be lordship, my lord. Once your lordship dealt with this matter, police constable of service.
Then what happened now?
My lord.
Now what happened?
Then you lordship directed the authority, me to file an appeal. I filed an appeal from the order of judgment, my lord. So they rejected my appeal, and hence I am before lordship now.
Third counsel.
Followed in this method,
Arpit Sharma, senior counsel, assisted by Mr. S. Doctor, Mr. T. C. Sutial, and Mr. the respondent. The respondents are represented, no formal notices, however, extra copy of the permission. After returnable date. After 4 weeks. Okay.
When my lord is a case of discharge from service, there was also an appeal pending, my lord, ultimately disposed of in 2025. Hence we are before your lord.
4 more readings.
My lord.
Reading
Trading, my lord.
from the army. Assam Rifles.
Assam Rifles.
Yes, sir.
Notice at this stage, but still departed. And it's CDC appearing with the respondent, should notice it and go forward. Respondent, the representative, notice. Go back.
Public. Asking for candidates for the post of typist in the LIC. My lord will kindly come to page 21, my lord. Page 21. So it's a select list, my lord, dated 15 September 1993. The panel consisting of the names of selected candidates for the post of typist in order of merit is hereby approved. Candidate may be appointed as typist given against any vacancy subject to satisfactory medical condition, my lord. The petitioner's name is serial number 4. Now, what had happened, my lord? After the petitioner was selected in the select list, she was engaged in a contractual capacity in the LIC when the vacancy for her post arose. And she was subsequently, my lord, only regularized in her appointment on 30/10/1999. Now, my prayer, my lord, that I have sought in the petition is that whenever the vacancy have arisen, as per the select list, my lord, I ought to have been put up in a permanent capacity as a typist and not as a contractual employee. That is the extent of my prayer, my lord. I'm seeking notional benefits, my lord. Superannuated.
Notice at this stage, right?
My lord.
So there's LIC.
LIC.
Council for steps on respondent by speed post within 1 week from.
If I may pray, my lord, this matter may be tagged with a similar matter that we had conducted.
So let it be after the returnable.
I'm grateful.
After some time.
The petitioner, my senior is another two. This can be possible.
What is this here? Has to be done.
Your lordship, it's compassionate going.
You should notice at this stage. Third council for parties, you should notice within 4 weeks. MS,
S. Borwa.
as Borwa, you're for APDCL.
Sir, on behalf of
You have for
B. Das, standing for
D Das.
B. Das.
Respondents. Extra copy. Furnished in a period of 1 week from today. Matter will be listed after the return of the date.
What timing?
What is this?
The notice will be issued in this case.
What is this?
Because you have given a compulsory retirement in the from service.
Compulsory.
He has given a compulsory retirement from service. And because he was found to be intoxicated while on duty.
Appeal.
Might not appeal perhaps have been filed, but that appeal has been dismissed. Because there is all this matter at first went to Honorable Delhi High Court.
We will issue notice.
May kindly issue notice.
Third council for parties issue notice. Then we move forward. Data, it is CBC, appeal on behalf of within a period of 1 week. You can tell your senior that you got the notice issue.
Okay.
Your lordship. Retired in 2017 from Concordative Production Society. Then his gratuity was paid after protracted litigation on 27/11/24. And in annexure 4 at page 17, it was stated clearly that the gratuity was paid without interest. But according to the Payment of Gratuity Act, section 7(3)(a), it is mandatory that interest for the period should be paid. That is not yet. Interest for the belated payment should be paid. That is not yet paid.
Mr. S.S. Barwa and the council for petition, Mr. H. Respondent number
1 and 3 lots.
1 and 3. Petitioner is claiming interest on delayed payment towards gratuity. During the service rendered under the Sriman Concordative Collateral Society. Stop. Submitted that the society is notice written steps on respondent number 2 and 4 within a period of 1 week from today by speed post. And to be listed after the return of the date.
Problem.
May please lordship, here whatever not the petitioner, along with 500 others were appointed as for employees. In this case, the petitioner is a sweeper. He was born in 2008. There was suddenly in 2020, there was an inquiry regarding their appointment, and this court was approached. This court directed the DHS to show cause and hear them and collect documents and take necessary action. And director thereafter dismissed them. Against that, others came to court, but I could not come because I was a Rexa. Then after my service was done, I was a Rexa puller, somewhere working in a agriculture field. And I could not come. And his the child was also ill. That I have explained in paragraph 15, 16, 17 of my petition. Now, my lord, in the meantime, what happened? The other group who had come to court, my lord, their petition was dismissed by the single bench, went to division bench, and division bench was 2026 January, 30th January, allowed the petition and allowed them to be exempt. So, once I came to know that about that,
You want the benefit of the judgment.
yes,
The petitioner is entitled for the benefit of the order or judgment passed by the learned single bench. There, my lord, two cases, my lord. One is from my lord Dibrugarh, another is from Gwalpara, where the petitioners could show the my lord advertisement, select list, marking system, compilation, everything was there. Their honorable court has interfered. Not in these cases, my lord. No advertisement, nothing, my lord, in this particular case. There was a series of cases of various districts. Only my lord Gwalpara and my lord Dibrugarh got the benefit because they had got the entire my lord document. There, that relief was granted.
This is from
Otherwise,
which
Gwalpara. Otherwise, in all other cases, my lord, nobody has preferred in AP because they know they don't have any.
No.
and that here he was
It is
appointed
their
Gwal-
case that
he was
they could
appointed
not prefer an
Gwalpara.
appeal.
Not sir.
Therefore,
No.
they
He has not
benefit-
even preferred a rich petition on the first.
That's why I am here.
In 2019 terminated.
Should notice here.
Yes.
That Mr. Ravi Sharma, senior counsel, assisted by Ms. Mr. B.
I pay for all.
Mr. For all the respondents. This is extra copy. After the written verdict.
Well,
Hold on a minute.
This for regularization of it.
Regularization.
You know what appointed cut-off date?
Which
1 for
department?
1990.
Which department?
Lots of PNRD department, NXR 8, page number 26, year number 33. That is the appointment order. Yes.
Where is the order of the Supreme Court? Some order of Supreme Court is referred here.
Yes. Sir. That is the specifically mentioned in the government notification dated 22 July 2005, wherein cut-off date is.
That order is not here. Supreme Court order is not here.
No, not here.
You are referring to that order.
Anyway, they are after the cut-off date, their appointment is after the cut-off date.
Right. Mr. M. Sohil.
1, 2, 4, 5, and 6.
1, respondent 1, 2, 4, 5, and 6. Minus report about hearing for respondent 3. Petitioner claims regularization. Still working.
Yes. Sir.
Rendering services as what?
Yes, inserts Gaon Panchayat Secretary. Things in a Gaon Panchayat.
As charge down Panchayat Secretary.
And the coronavirus development law.
The representative notices of the extra copy furnished to the one. Still after the. Yes.
Okay.
Yes, your lordship. I take your lordship. Supreme Order page 39, my lord, Annexure 7. This was passed pursuant to your lordship order at page 37. Page 37. There was specific my lord, instruction to the my lord by the Election Commission Standing Council that petitioner case is not covered under the Election Commission guidelines. Thereafter, page 37, paragraph 3, lordship observed that, my lord, in view of the exemption, paragraph 3 down below, provided under the ECI guidelines dated so and so, and since the petitioner was required to continue this posting, this court by the earlier order dated 6/4/2026 issued an interim order by granting interim protection
to the petitioner, my lord. And that was as per election commission instruction that, my lord, this case do not fall. And only 1 year, 4 months is there, my lord. Petitioner is there, my lord, from the date of earlier transfer order. And my lord, the government of Assam guidelines regarding transfer policy, my lord. Take your lordship to the guideline. Page, my lord, 41, my lord, annexure 8. May I read, my lord? The undersigned is directed to refer to the government office memorandum dated so and so, wherein it was laid down categorically that whenever public interest demands an officer be transferred from from his place of posting before completion of normal tenure of 3 years in a particular post, place proper justification with credible ground be adduced in writing for such transfer, and order effecting such transfer shall be issued only after securing the approval of the Honorable Chief Minister. However, of late stipulation of taking the prior approval of the Chief Minister is not always observed while effecting the transfer and posting of the government officers before completion of their normal tenure of 3 years. Then, my lord, all administrative departments are therefore advised to ensure that no transfer officer is transferred without completing the 3 years in a particular place of posting unless it is on promotion. In case circumstances require the transfer of any officer before 3 years in the existing exigency or public service or for other reason, the approval of the Honorable Chief Minister should invariably be obtained before such transfer. So, my lord, in my case, my lord, no such approval was there, and this is an election transfer as per their instruction, my lord. And my earlier transfer order was passed in, my lord, 2024 October, my lord.
Yes.
But if otherwise the representation has been disposed of and subsequently the order has been passed.
Now, there was some interim order in operation.
Yes.
Till disposal.
Till disposal, and my lord, how the order was passed, my lord, they treated the order of the court, my lord. Lordship, kindly see page 40. Lordship, kindly see. Accordingly, the transfer order issued by notification number so and so dated 15/3/20 shall remain valid and inoperative, and so and so is hereby stand released from his post with immediate effect and directed to join at the place of the Assistant Registrar of Cooperative Societies, Lakhimpur, within 24 hours of issuance of this order. Any continued non-compliance shall be viewed seriously. My lord, there was no lordship order is there. On that basis, my lord, he was in the office. And Deputy Commissioner order is that is on record, my lord. And in terms of their own guidelines, my lord, my earlier transfer order is page 16, my lord, annexure 1. This is of 24/10/2024, my lord.
You are already released now.
My stand release, my lord. That is by the secretary, my lord. That order has to be followed by the subsequent authority, my lord. Yes.
Where are you posted now?
I'm in Nagaon, my lord.
Huh?
He was transferred from Nagaon to, my lord, Lakhimpur, my lord. Order passed on, my lord, 8th, and he was asked to join his new place of posting within 24 hours, my lord.
Third Council for Parties issued. Mr. Borduan. All the respondents. Petition scored challenge to the order dated 8/6/2026, whereby his representation filed earliest to rejected, and the petitioner has been released from his place of posting with immediate effect and directed to join the office of Assistant Registrar Cooperative Societies, Lakhimpur, within 24 hours of issuance of this order. So, the petitioner had earlier, who was serving as Senior Inspector Auditor of Cooperative Societies, Office of the Assistant Registrar Cooperative Societies, Nagaon. So, by order dated 15 March 2026, petitioners to transfer to his place of posting in Lakhimpur purportedly in terms of the Election Commission of India guidelines, state assembly elections which were scheduled at the relevant point in time. So, results before the court that the petitioner was posted in Nogao. When were you posted in Nogao?
24/10/2020. 24, madam. 24, page 16.
24/10/2020. Stop. Therefore, terms of the guidelines which are issued by the state regarding transfer and posting, he is required to be posted in the place for 3 years. Therefore, transfer of the petitioner by March 2026. Ordinarily, not have been issued without violation of the guidelines. So, however, it was an order issued purportedly under the Election Commission guidelines. Now,
Yes.
district. So, then the petitioner approached the court by filing WP 1953/26. It was submitted before the court that the representation was pending before the court. Petition being to be disposed of. So that they come before the court on bench only, the order was passed, giving interim protection to the petitioner. That's the transfer order. Subsequently, the petition to be disposed of that by order dated 6/4/26 on the ground that there was a representation already pending before whom? Commissioner. Secretary of Cooperative Society. Corporation Department. And the same should be disposed of expeditiously as view of the submissions of Standing Counsel for the Election Commission that since the elections were already over. When were the elections?
9th of April.
No. The petition was disposed of with the direction to the concerned authority to dispose of the representation. Stop. By which order was it disposed of?
My lord, lordship, kindly see page
27, 5,
27/5.
page 37.
Page 30.
27/5/26. The interim order that was granted earlier was to be extended till the date of the disposal of the representation. Stop. Thereafter, by the interim order, 8/6/26, the transfer order, the representations to dispose of. Stop. What about the reliever?
Reliever is not there.
How can that be?
My lord, lordship, page 40, my lord.
How can the reliever not be there? Somebody must have
My
come.
lord, limping order reliever is not there. Page 40. 39.
So in your original transfer order, who was the person in your place?
My lord, original transfer order, my lord, page 27. ARCS looking.
27.
Serial number 2.
So in your place in Nogao, who has come? There is one Dokhinpur.
One Lakhimpur to Nagaon, your lordship. Serial
He's
number
come.
1.
Serial number 1,
One,
page number
But
27.
name is not there.
You have not read him a party.
But order, my lord. The
Order may not be there, but this 27B.
Yes.
The person at serial number 1 has been transferred
yes, from Lakhimpur to Nagaland.
Lakhimpur to Nagaon. Must have joined already.
Maybe to this time would have partner.
We want to know what has happened. Submitted that. Action, the improved order by rejecting the representation did not refer to the guidelines issued by the government regarding transfer and posting, where officers are normally not required to be transferred within 3 years. Stop. It is also submitted that there is also no dispute that the transfer order dated so and so was issued in terms of Election Commission Model Code of Conduct. As is seen from the recital of the order. So, under such circumstances, the Council for the Petitioner submits that there is malice in law, as the authorities have deliberately failed to explain the reasons and grounds for transfer of the petitioner prior to completion of 3 years. Its place of posting. So, we therefore submit that the order be independently set aside and suitable direction be issued to the respondents. So, Mr. Bodoloi, the standing counsel on the other end, submits that what?
Worship, the order has been passed pursuant to the order of the Honorable Court.
He submits that the order has been passed in reference to the orders passed by the court. This case has been rejected. Like to complete the instruction. According to Mr. Bodoloi represents all the respondents, notices away, the extra copy will be furnished. The next returnable date in the order dated 6/2026 shall not be made effective so far as the liquidation is concerned. This matter immediately after the returnable date on 15th of July. Public. Yes. What's the matter about?
My lord, we have received that group insurance schemes has been received by the petitioner recently.
You don't want to press it. No grievance.
But that come retirement benefit has not been received. Insurance scheme has been received, but the debt-cum retirement benefit has not been received by the petitioner. Because as per the affidavit of the respondent, affidavit of the opposition, saying that petitioner is not entitled as the petitioner husband has not served for 20 years, less than 20 years.
Yes.
Lordship, may kindly peruse page 65 annexure 17, Lordship. Lordship, we've already asked the private respondent who objected to the sanctioning of the family pension, Lordship, regarding his objection, but we have not received any instructions from them,
Who
Lordship.
is the private respondent? Who represents the private respondent? Any counsel?
Accountant General, madam. If you responded 4, madam. Srimati Nirmal.
The respondent number 5?
5 minute is the relationship of his business husband, madam.
Where is the scope for objection?
No, madam. Already, the pension is already finalized, madam.
Finalized.
GPF also, madam, our affidavit, madam.
So what is the stage now?
Stays on a DCRG, madam, whether as per this, our affidavit, madam, service was not confirmed, madam. Service was not confirmed, madam, and below 2020. So it is entered as per our affidavit. So other benefit, the Krishna already.
GPF and family pension
Yes,
has been finalized.
yes,
Now DCRG is not admissible.
yes.
Under what provision? It requires 20 years.
There is my office memorandum, my lord, here, my lord.
Where is that?
Some services pension manual, my lord, this my lord, 6 September 2003, my lord.
Yes. Which one? Page number?
But my book, my lord, page now 190, my lord, and some other, my lord, in 186, my lord. After, my lord, they ruled 152, my lord.
152.
Chapter 9, my lord, special
Yes.
provision.
Then
There-
OM dated 6th of September.
my lord, 6 September.
Yeah.
So, since it's open 20 years continuously without being confirmed. Pension first. Years continuously.
This is for pension.
It's pensionary benefit, my lord.
Then what about DCRG?
This year also, my lord, is here, my lord, and the rule 136, my lord. (36)2, my lord, an officer shall, as soon as he is confirmed and completes 5 years qualifying service. And mean nomination, my lord. 5 years qualifying, my lord, service has to be confirmed, my lord. As per our record.
No, you are reading from where?
Rule 136, my lord.
136.
2, my lord.
Madam, you're not entitled to DCRG.
No, my lord. My lord, on this topic for argument, my lord may fix another day.
What is this 2015 matter you are keeping on arguing? What is this? Why another date?
My senior is out of station.
Who is your senior?
PK sir.
This is not the way to drag on a matter for so many years, 7 years,
Because we are relying on this.
11 years. When is he coming back? So let us have it tomorrow.
I'm planning to.
No, don't plan, change your
My
plans.
Bhubaneswar already taken.
Huh?
Bhubaneswar for 1 week.
You ask your colleague to be present. We are examining the provisions.
Yes.
You instruct someone to be here.
Yes.
Please this matter tomorrow as it is submitted that Mr. DK Singh, counsel for the petition, is after station. And considering the fact that this matter belongs to the year 2000, list on tomorrow. Please inform your senior. Mr. S.K. Medi for the respondent, that is the board of report, the finance, PW.
My lord, maybe it's on 16, my lord.
No. But this is how the matters get delayed. We are trying to accommodate all councils, therefore matters get delayed. And then you bring the court, that court is not taking up matters.
I am not there. I do. From surveys on the reading, my lord, but then the affidavit appears to be already filed, my lord, but then somehow my copy is missing. I have to take a fresh copy.
Take a fresh copy, give a fresh copy. Mr. B. Pathak, counsel appearing for the petitioner, submits that court records reveal that an affidavit has been filed by the respondent. However, we have perhaps misplaced the copy. Submits that some time be granted to reconstruct his will. Counsel for the respondent will also submits that she will furnish extra copy of the affidavit filed by the respondent within 2 days. Matter be therefore listed after the ensuing vacation on a date to be fixed by the registry. Liberty is granted to the petitioner to file rejoinder if so advised.
RD is on lake. RD is on lake.
This matter related to regularization of master road workers. All the materials is pending. It's on 16th. Then Advocate General will appear in this matter.
Where?
For court number on 16th. I will give the
No. This is pertaining to what? Veterinary department.
No, Lordship, regularization of master road workers. Not veterinary department although. But it relates to the regularization of master road workers. Earlier it was covered by Upendas.
So
The other matters are pending.
maybe pending, you examine and tell us.
We have already filed our application in this matter.
Yes, you informed Mr. Day, 2 p.m.
Okay.
Proceed. As per order dated 17/3/26, that the report of Assistant Commissioner has been on record by way of filing
Additional affidavit.
It's not additional. Yes, Lordship, additional.
What effect? Or why have you filed this additional affidavit?
Because Honorable Court directed on the 17/3/26. We have submitted
the Assistant Commissioner's report as regard the residential status of the petitioner. And that status, Honorable Court directed to bring on record by way of.
Yes.
We have received this copy yesterday only, so it's some time to take instruction.
Now, where is the evidence that the petitioner is a resident?
This is this is the report, Lordship, page number 68.
68 is a communication, submission of report.
Yes, Lordship.
Now, petitioner is seeking appointment under which Anganwadi?
Koirabari Anganwadi Center. Yes, after marriage, you become point number 2, Lordship. Point number 1, Srimati Pompi Mohanto was a resident under number 2 Koirabari Anganwadi Center up to 30/11/2020. Number 2, after her marriage, with effect from 30/11/2020, she shifted her residence and has since been residing under the jurisdiction of Saheb Topa Anganwadi Center. Point number 3, it is pertinent to mention that the Anganwadi worker number 2 Koirabari Anganwadi Center expired due to cancer, and as a result, the name of Srimati Pompi Mohanto was not removed from the register. Hence, her name continued to reflect in both registers despite the change in her actual place of residence. However, it is clearly verified that after her marriage, she has been an actual and permanent resident under Saheb Topa Anganwadi Center.
Reference to the earlier orders passed in this matter that the Commissioner Tamulpur will conduct an inquiry and submit a report as to the places of residence of the writ petitioner and respondent number 6. So, as to whether the petitioner and respondent number 6 are local residents within the local area of number 2 Koirabari Anganwadi Center. Stop. District Commissioner Tamulpur has filed an additional affidavit enclosing the report and address to the district, enclosing the report of the Assistant Commissioner Tamulpur by the report dated 1/12/2025. Stop. As per the report, the petitioner was a resident of number 2 Koirabari Anganwadi Center up to 30/11/2020, after which she got married and subsequently has become permanent, subsequently has been residing under the jurisdiction of Saheb Topa Anganwadi Center. So, the name of the petitioner was not removed from the register maintained in the number 2 Koirabari Anganwadi Center, and her name also appears is not removed from the same register. So, as per the report, after marriage, petitioner has been an actual and permanent resident of Sahib Topa or Manwari Center. This information is brought by the additional affidavit filed on 10 of June 2026. Mr. B.B. Kakoti, Learned Counsel, appearing to submits that we would like to complete their instructions in this regard. Please for 3 weeks' time. Accordingly, matters hence referred to be listed. After 3 weeks, Mr. Ahmed appears for respondent number 6. MS Runso appears for respondents 2, 3, and 4. S. Borua for respondent number
1 and 5.
1 and 5. Relist after 3 weeks.
Oblique.
Some instruction was sought for.
Yes. What instructions are there?
Regarding the non-communication.
APA.
Yeah. Last page also. Yes, duly acknowledge the district of FPR. Eleven.
What exactly are they trying to say? Your
Their contention was that
legal cell. What are they trying to communicate?
it was their claim that he has not, the APR was not communicated to him. And as per the Lordship, it is required to be communicated. So as per Lordship, this document, he has duly received the APR. Lordship.
They say at para 9, you have already made a statement, it was communicated to you.
But,
Thereafter it was communicated and I made a representation against the same. That representation gets lost.
In para
This is the difficulty.
Para 9 Lordship, the acknowledgement certificate was not annexed.
But from your records, how have you communicated? To communicate the APR, how do you do it? Do you just bring it and put it under their nose? Or you do it by way of a communication? Then show us that communication, how you have communicated.
He communicated and he has
By which communication?
And he has duly acknowledged Lordship, the receipt of the APR. Last page, Lordship.
This is before the selection, before the DPR. What do you call the DPC?
DPC, he is claiming Lordship the third MSCP.
Ah.
And his grade is only 5 Lordship and it is good. It is not an advanced Lordship APR, but his grading was, his grade was low, therefore his.
I need 7 for getting the.
He could not be recommended.
No, you are agreed that your APR was not communicated.
That,
This is it.
there are two aspects. One is, my lord, that initially it was not given. Then when it was given, I, at annexure 2, my lord, I submitted the representation for upgrading the same. Now, in affidavit, my lord, they say that though it was duly forwarded, my lord, they say that we have lost it. Therefore, we could not act upon it, my lord. There's a statement in the affidavit that we have lost it. Then essentially, my lord, communication, the purpose of communication is that I get a chance to represent against the same.
Even in his representation notes, the lordship, he has admitted his lapse.
What lapse?
Whatever lordship pointed out in the lordship assessment. Is
Where is that ever meant in the affidavit?
getting left.
That they have lost it?
Page 58, my lord.
58.
Page 58. Para 14. That with regard to the statement within para 18, component submits that representation of the PC by the Director General Assam Rifles to chain of command. However, same was returned due to recommendation of the was not found. However, the same was lost in transit. Hence, respondents were unable to consider his recommendation.
So they have acknowledged that if you submit, they will continue.
It's already there on record.
Huh?
It's already there on record, man. My petition also, this is there on record. And in fact, I have also stated that thereafter, when my service review took place after completion of 30 years, I was retained in service on the basis of upgraded my lord ACR. But then as far as MSCP is concerned, my lord, they are not taking into consideration.
Doesn't granting was only good lordship for granting MSCP, it refers to be above
It's to be 7. So it's to be above.
above.
So what is to be done? You have already admitted that if they file a fresh representation,
Submit.
he is already filed.
It is lost lordship, therefore a fresh representation may be submitted lordship, and the department will consider it.
Is any further representation enclosed here, Mr. Pathak?
No.
File it as per this statement made in the affidavit.
And file it afresh again also. But then this also has to be read as part of the record.
Which
Otherwise, the question of now filing a fresh. This annexure 2, continuation of that, I can file another, my lord. But then this has to be acknowledged. It's there because this is, my lord, duly forwarded at annexure 3, my lord.
It is acknowledged also that it was received, but
So then why don't you consider this representation itself? When you acknowledge that this particular representation is there and it got misplaced, why don't you consider this representation and annexure 2? Why are you
submitted afresh lordship?
why afresh? What is the point? Whatever what grievances he has is already there reflected in annexure 2. You admit that it was submitted but lost in transit. So you reconsider this. If you want, he can submit a fresh copy of this representation.
Yes, please copy submitted.
Heard Mr. B. Pathak, Learned Counsel for the Petitioner, Mr. NSR Devi, Learned CGC, the respondent. The runs of the petitioner is that his claim for grant of MSCP -3 Roman 3. Upon completion of 30 years of service, was not granted, as according to the respondents, the petitioner did not meet the required benchmark. Stop. The petitioner submits that he had ventilated his grievance by way of representation dated
18 June 2022.
18 June 2022, and which was not considered by the authorities, and without consideration of the same, the claim of the petitioner stood rejected. Stop. The respondents have filed their affidavit, and there is a clear averment in the affidavit that the respondents had duly received clear averment at para 14 that the respondents had received the representation, but the same was lost in transit, and therefore they were unable to consider his representation. So the para 14 of the affidavit is extracted below. In deference to the earlier orders passed by the court, the learned CGC has placed before the court the instructions received which reflect that the petitioner was duly communicated the APR, which is reflected in para 9 of the writ petition. Although the earlier orders of the court reflected that the APR was not communicated. Stop. According to the learned council, learned CGC, as per the records, the APR was duly communicated. So what is further evident, what is further evident also from the affidavit is that the APR, the representation against the same representation of the petitioner was also received, but before it could be redressed, the same was misplaced in transit. Stop. Learned CGC on instructions submits that a fresh representation, if filed, can be examined and disposed of by the respondent authorities. Stop. There are having heard counsel from the parties and of the amendments made in the pleadings which are exchanged, you can see that in the writ petition at Annexure 2, the petitioner had already represented before the Director General of Assam Rifles, requesting for upgrading the APR gradings covering the period 1st of April 21 to 31st March 2022 by his representation dated 18th of June 2022, and which the respondents have admitted the receipt thereof, but the same could not be redressed as the same was lost in transit. Stop. That view of the matter, permit the petitioner to submit a duly attested photocopy of the representation available at Annexure 2, dated 18th of June 2022. The Director General, which is available in Annexure 2, so that the respondents can examine the claims made by the petitioner and pass appropriate orders as to whether the upgradation of the APAR, the writ petitioner, can be as to whether the petitioner is entitled to application of his APA. So let this representation be filed within a period of weeks from the date of receipt of the certified copy of his order, and thereafter the respondent will dispose of the representation within a further period of 4 weeks.
1 month.
4 weeks from the date of receipt of the same representation along with a certified copy of this order. Disposed. Interim orders, if any, stands merged.
Case on 18/5, Mr. R. Dhar has taken some time to complete the instruction regarding claim of the.
Yes, any orders?
Lordship, in this case, Lordship, the petitioner returned on 31/8/2019, Lordship. And an order was issued on 30/9/2020, wherein Lordship, the petitioner was given retrospective promotion with effect from 24/8/2019. So after retirement, his PPO has been issued, considering his service as junior engineer. Now, this period, Lordship, 24/8/2019 to 31/8/2019, it's 6 days period, Lordship, is claiming benefit in terms of that promotion order as per the scale of assistant engineer, Lordship. Lordship, initially, this section, I mean, FRS 17 approval was not there because creation of post was necessary there. But subsequently, Finance Department has given its approval. And accordingly, Lordship, on last 8th of June, Lordship, this month, the comparative statement of the due drawn statement, Lordship, and his necessary documents, Lordship, has been forwarded to the AGO for their consideration. Because it will require some, modification of the PPO.
Yes, AG. Huh?
I do not have any instruction regarding.
When were they forwarded?
It was one was forwarded on 8/6, Lordship. Another copy was forwarded on 4/6, Lordship. This month.
Do you have a copies of the communication you furnish it to the council? You get the instructions. Let it be after the vacation. MS R. Chaudhary, done as consisted by MS. So and so. For the petitioner, Mr. Iyer, lady appears for PWD. And Mr. Borua appears for Town Engineer. According to Mr. Nayak, on instructions received, the relevant papers have already been forwarded to the Accountant General, which will now require consideration and changes in the PPO, subject to such orders being passed by the Accountant General's office. Mr. Borua, on the other end, submits that you would like to complete his instructions. Accordingly, he has agreed to this matter again on 27th of July.
Update.
Appointment of arbitrator.
Yes.
Lord finds the agreement at page 17. This was for construction of an administration residential dormitory building and shop buildings at Sipa, Germany. This was with the Pragjyoti Textile Park Private Limited. Now, your Lordship may straight away come to page 101, which is the general conditions. Page 101 is where your Lordship finds the arbitration clause. 4.16, all disputes and differences arising out of or in connection with the contract, whether during the progress of the work or after completion, shall be referred to and settled by arbitration by two arbitrators, one to be nominated by the employer, that's them, and the other by the contractor, that's me, In the event of the arbitrators agreeing, it shall be referred to an umpire to be nominated by the two arbitrators before processing with the arbitration. The decision of the umpire shall, however, be final and binding on both the parties. For the purpose of this clause, the provisions of the Indian Arbitration Act 1996 with relevant amendments shall be acceptable. The jurisdiction of arbitration will be at Gauhati, Assam. Language for arbitration shall be at English. Lord, I'll not trouble your lordship with the dispute. And Lord, that's a typical dispute where I say the site was not handed over in time. They say there was delay in works, there were delay in approval of plans, etc. And eventually that culminated into the dispute. And page 65 is when we send the first request for arbitration. There were pending bills, this is dated 23/9/2023. If I may read this one. I, the undersigned, by means of this of the instant formal communication, request you to come forward for appointment of arbitrators for the purpose of resolving the disputes as per clause 4.16 of the NIT. The process of arbitration in connection to the dispute of non-payment of RA bills, as mentioned hereunder by your good office, for our work undertaken by the undersigned. I state that Mrs. RD Enterprises had emerged as a successful bidder for the work awarded through the NIT and agreement referred above. Pursuant to the above, I had undertaken construction works as per the terms and conditions of the agreement, and also the bidding document, more particularly 4.3 of the agreement and 4.13 of the bidding documents. The undersigned was required to submit RA bills with certification from the site engineer. It is with immense regret that I beg to inform you that 3 numbers of RA bills they numbered so and so have remained unpaid for reasons best known to your office. It has nearly been 4 years ever since the submissions of the RA bills and the certification of the concerned site engineer, but no payment is seen forthcoming from your end. It is needless to say that owing to the non-payment of RA bills, the undersigned had suffered severe financial losses and is consequently unable to carry on with the construction works. It must be borne in mind that the project was stipulated to be time-bound in nature, and completion thereof is subject to interim payments as envisaged in the contract. Several reminders and representations, both oral and documentary, have gone from our end, but it is regretted that no response has been received from your good office till date. You have time and again ignored the legitimate pleas of the undersigned, as such have been compelled to refer the instant intimation requesting you to come forward for resolving the dispute by means of the process of arbitration. The rest, the clauses are quoted, Manoj, and at page 66, your lordship finds the nomination. 66, the following page. As such, I request the last paragraph. As such, I request you to kindly treat this notice as urgent and come forward for appointment of arbitration.
Where is the name?
SP Moitra.
Not here. Blank.
Even in my document record, it is blank.
Anyway,
this was not responded to, so therefore, this was not responded to, and then having no other
it was not responded to perhaps
because the name. Let us assume that for the moment, but there's more to the correspondence. So eventually, Manoj, we sort of terminate the contract, being unable
to. After 23.
Yes.
9.
Yes.
There is another one.
Yes, yes. That's on the following page, page 67. There again, Manoj, we reiterate the request for the arbitrator. This is a composite notice where we terminate the contract and also reiterate our request for appointment of an arbitrator.
Here it is named.
Yes.
In this also there is no response.
In this also, the same name was proposed that I can produce.
Yes.
So
then 11.6.
Then 11.6. Now I've gone through the objection, Manoj. If I may just take your lordship through page 198, if your lordship had 196 onwards, part of para 3. They are referring. This is their affidavit in opposition. They're referring to the clause in the agreement which contemplates payment within 21 days. So essentially, their case is that those RA bills were raised way back in 2018, and therefore the cause of action must have arisen from that date, and by now the limitation has gone. So should I respond? Now, my lord, the judgments are clear, my lord. So far as limitation is concerned, my lord, there can be two types: whether I have approached within 3 years from the request, or whether the claim itself is barred by limitation. The courts have said, my lord, latter question should be left to be decided by the arbitrator. This is one line of judgment. My lord. Secondly, even otherwise, even if it's seen whether it's ex facie barred time barred claim or not, that also I'm protected because given their own calculation, my lord, I would get the benefit of that Supreme Court order of COVID-19. That extension I'll be entitled. Because going by their calculation, if we take note of that particular suo motu order, my lord, this would end on 12th.
You want to say the limitation to be counted from which notice? 23 or 24?
23.
23. Then you get a benefit of
the exemptions for COVID. So that was something that was taken note of recently in another article. Anyway, I'll place them after my friend. So as I see it, Manoj, so far as the objection is concerned, it is only as regards limitation, Manoj. First of all, I would say that this question of limitation is whether the claim itself is barred by the time. But insofar as
there is no objection that 11.6 is barred by limitation.
No, there cannot be because 23 I raised the request, 25 I 24, 23 and 24 I filed the request, 25 I filed this petition. So therefore, on that count, under Article 137, there cannot be a question of limitation. Their contention perhaps is that the claim itself, which I eventually lodged before the arbitrator, that could perhaps be a barred by time. That question again, place the judgment. Is to be ideally left for the arbitrator to decide, so long as the application appears to be within time. I'll place them.
The learned president rightly said that under section 11.6, that will be decided by the arbitrator. But my point is, Your Honor, when the ex facie claim itself is under limitation and turns to be a dead wood, the Supreme Court in GSNL versus Nortel case have dealt with this issue. And even this Honorable High Court has dealt in JCL Infra.
Subsequent judgments have said referral court is into the valid arbitration.
Yes, but your lordship, my point is the benefit that they are trying to draw with the COVID judgment from the Honorable Supreme Court doesn't include section 21. It specifically includes section 23(4) and 29A of the Arbitration Act. 23(4) and 29A of the Arbitration Act. If they had claims, they should have issued the notice within the limitation period.
23(4) and
29A of the Arbitration Act.
29A.
I'm having the judgment of the Honorable Supreme Court also.
So your objection is to which aspect? Both the aspects.
Both the aspect, because they have taken two defense. One, they are saying that they have placed on record the arbitration notice in 2023. My point is, I have raised objection in page number 197 and 198 of my affidavit in opposition. I have given a detailed tabular representation. The first RA bill pertains to 2018. The period of limitation for that expired on 18/7/2021. The next RA bill was raised again on June 2018. The limitation expired on 18/7/2021. The last RA bill was on October 2018, expired on 25 October 2021. So any notice of arbitration for non-payment of their dues should have been within or prior to this 25/10/2021. They have issued the notice of arbitration on 23rd September 2023.
Yes.
And the BSNL judgment.
No, did you raise the objection? The notice, there was no response.
There was no response because they themselves in their notice Your Honor, may kindly have page 65 of their petition. The first para, after they have mentioned the RA bill, it has nearly been 4 years since the submission of RA bills. Prior to that, there was no such claim. Only 23/9/2023, they are issuing an arbitration notice where they are themselves mentioning that it has been nearly 4 years ever since the submission of the RA bills and the certification by the concerned site engineer, but no payment is seen forthcoming from your end. This entire case requires the test mentioned under this BSNL judgment. Otherwise, it will defeat the purpose of the act.
Can I take the judgment before I draw the paragraph? But I'll start with the BSNL judgment.
I am placing it on record.
Paragraph 15 onwards is the local time.
Yes.
Paragraph 15. It is now fairly well settled that the limitation for filing an application under Section 11 would arise only upon the failure to make the appointment of the arbitrator within a period of 30 days from issuance of the notice invoking arbitration. In other words, an application under Section 11 can be filed only after a notice of arbitration in respect of the particular claim disputes to be referred to arbitration as contemplated by Section 21 is made, and there is failure to make the appointment. Para 16, the period of limitation for filing a petition seeking appointment of an arbitrator cannot be confused or conflated with the period of limitation applicable to the substantive claim made in the underlying commercial contract. The period of limitation for such claims is prescribed under various articles of the Limitation Act 1963. The limitation for deciding the underlying substantive disputes is necessarily distinct from that of filing an application for appointment of an arbitrator. The position was recognized even under Section 20 of the Arbitration Act of 1940. Reference may be made to the judgment of this court in J.C. Budhraja versus Orissa Mining Corporation Limited, wherein it was held that under Section 37(3) of the 1940 Act provides that for the purpose of the Limitation Act, an arbitration is deemed to have commenced when one party to the arbitration serves on the other party a notice requiring appointment of an arbitrator. Para 26 of the judgment reads as follows. Section 37(3) of the Act provides for the purpose of the Limitation Act, an arbitration is deemed to have commenced when one party to the arbitration agreement serves on the other party thereto a notice requiring the appointment of an arbitrator. Such a notice having been served, it has been seen whether claims were in time as on that day. If the claims were barred on so and so, it follows that the claims had to be rejected by the arbitrator on the ground that the claims were barred by limitation. The said period has nothing to do with the period of limitation for filing a petition under Section 8(2) of the Act. Insofar as a petition under 8(2) is concerned, the cause of action would arise when the other party fails to comply with the notice of invoking arbitration. Therefore, the period of limitation for filing a petition under Section 8(2) seeking appointment of an arbitrator cannot be confused with the period of limitation for making a claim. The decision of this court in so and so also makes the position clear. So what is urged in paragraph 3 is that you raised the bill in 2018. You have not initiated the arbitration on time. So therefore, when you raise that, your substantive claim for recovery of the amount is itself barred by limitation. Now that, according to this judgment, is not to be confused with the aspect of limitation which the court under Section 11 is concerned. Now, however, there were subsequent judgments which have said that yes, maybe not through the lens of limitation, but the Section 11 court can of course see if it's an apparent dead claim, maybe on the ground of limitation. So that exception is of course there, which was enunciated in Arif Azim Company Limited, which your lordship finds.
Let us first complete this judgment.
Yes, yes.
What,
No,
what are
this
the
is
paragraphs
the
that you are trying?
this is the distinction. So therefore, I wanted to rely on this. Then thereafter the exception to this. Anyway,
Can you come back to para 20, extracted para 26 again?
Yes, yes. Section 37(3) of the Act of 1940 provides that for the purpose of the Limitation Act, an arbitration is deemed to have commenced when one party to the arbitration agreement serves on the other party thereto a notice requiring the appointment of an arbitrator. Such a notice has been served on 4/6/1980. It has to be seen whether the claims were in time as on that day. If the claims were barred on 14/6/1980, it follows that the claims had to be rejected by the arbitrator on the ground that the claims are barred by limitation. The said period has nothing to do with the period of limitation for filing a petition under Section 8(2) of the Act. Insofar as a petition under 8(2) is concerned, the cause of action would arise when the other party fails to comply with the notice invoking arbitration. Therefore, the period for filing a petition under Section 8(2) seeking appointment of an arbitrator cannot be confused with the period of limitation for making a claim. The decisions of this court in Inder Singh Rekhi versus DDA so and so also make this position clear. Various high courts have taken the view that Article 137 of the Limitation Act would apply to an application under Section 11 of the Act. The question of applicability of Article 137 under Section 11 came up for consideration in so and so, wherein it was held that the period for an application under Section 11 would be governed by Article 137 of the Limitation Act. Subsequently, in Deep Darshan Builders vs. Saroj, the Bombay High Court framed the following issue. Whether Article 137 of the Schedule to the Limitation Act 1963 would apply to arbitration application filed under 11(6) of the Arbitration Act. And if applies, whether Section 5 of the Limitation Act would be applicable to this arbitration application, and if Section 5 applies to this arbitration application, whether the applicant has made a sufficient cause for condonation of delay. The Bombay High Court held in so and so. In my view, since the proceedings under 11(6) of the Arbitration Act are required to be filed before the High Court, Article 137 of the limitation to schedule to the Limitation Act 1963 would apply to such applications filed under 11(6) of the Arbitration Act. In my view, since Article 137 of the Schedule to the Limitation Act would apply to arbitration applications under 11(6) of the Arbitration Act, Section 5 of the Limitation Act 1963 would also apply to the arbitration applications filed under 11(6) of the Arbitration Act. It is not in dispute that under Section 20 of the Arbitration Act of 1940, an application was required for taking the arbitration agreement on record and for appointment of an arbitrator in accordance with the arbitration agreement before a court. Since the said proceedings under Section 20 were required to be filed before an appropriate court, the provisions of Article 137 of the Limitation Act of 1963 were applicable to such proceedings filed before such appropriate court. In my view, since the proceedings under 11(6) and 11(9) of the Arbitration Act for seeking appointment of arbitral tribunal are also now required to be filed before the High Court or the Honorable Supreme Court, as the case may be, Article 137 of the Schedule to the Limitation Act of 1963 would apply. It is not in dispute that no article of the Schedule to the Limitation Act provides for any other period of limitation for filing an arbitration application filed under 11(6) or 11(9) of the Arbitration Act respectively. It is not in dispute that Article 137 of the Schedule to the Limitation Act 1963, such application has to be filed within 3 years from the date when the right to apply accrues. In my view, under Article 137 of the Limitation Act, application for appointment of an arbitrator under 11(6) or 11(9) of the Arbitration Act before the High Court or the Honorable Supreme Court would apply from the date when a notice invoking an arbitration agreement is received by the other side, and other side refuses to the name suggested by the opponent or refuses to suggest any other name in accordance with the provisions of section 11 of the agreed procedure prescribed in the arbitration agreement within time contemplated therein.
What is the limitation for failure to concur on the request made under 21?
Yes.
What is the limitation?
3 years. 3 years, and that 3 years would
3 years you have to file your 11/6.
11/6 from the date of the notice. So that is the main
You filed it in
23, and we filed it in
23
25.
September.
Yes. And we filed the application under 25. So viewed from that angle, my lord, the application is perfectly within time. What they are trying to urge is altogether different. They're not saying
claims itself are
the
time.
claim is a part. So here they make a distinction that part you leave it for the arbitrator to decide. However, subsequently and even in the later
in this BSNL judgment.
Yes.
Which paragraphs?
Paragraph 15 is where the distinction is drawn because they draw that parallel from the Act of 1940. Now, the subsequent judgment of Arif Azim discusses all of this and gives an area where the court can look into if it's altogether a dead claim. If your lordship has the following judgment. The longest judgment, all judgments including BSNL have been discussed from para 56 onwards, but it has been very succinctly summarized.
Let us first, since we are in BSNL,
yes,
you can just refer the paragraphs. I think paragraph 38 or something. Yes, 38.
38 and 39.
39.
Yeah. Limitation is normally a mixed question of fact and law and would lie within the domain of the arbitral tribunal. There is, however, a distinction between the jurisdictional and admissibility issue. An issue of jurisdiction pertains to the power and authority of the arbitrators to hear and decide a case. Jurisdictional issues include objections to the competence of the arbitrator or tribunal to hear a dispute such as lack of consent or a dispute falling outside the scope of arbitration agreement. Issues with respect to the existence, scope, and validity of the arbitration agreement are invariably regarded as jurisdictional issues since these pertain to the jurisdiction of the tribunal. Admissibility issues, however, relate to procedural requirements such as the breach of a pre-arbitration agreement required, for instance, a mandatory requirement for mediation before the commencement of arbitration or a challenge to a claim or a part of the claim being either time-barred or prohibited until some precondition has been fulfilled. Admissibility relates to the nature of the claim or the circumstances connected therewith. An admissibility test is not a challenge to jurisdiction of the arbitrator to decide the claim. This 40 is important. The issue of limitation in essence goes to the maintainability or the admissibility of the claim which is to be decided by the arbitral tribunal. For instance, a challenge that a claim is time-barred or prohibited until some precondition is fulfilled is a challenge to the admissibility of the claim and are not a challenge to the jurisdiction of the arbitrator to decide the claim itself. In Swiss-born Diamonds Mines versus Kingdom of Lesotho, the Singapore Court of Appeal distinguished between jurisdiction admissibility in para 207 and 208, which read as jurisdiction is commonly defined to refer the power of the tribunal to hear a case where admissibility refers to whether it is appropriate for the tribunal to hear it. Waste Management INC versus United Mexican States to the Zachary Douglas adds clarity to this discussion by referring to jurisdiction as a concept that deals with the existence of the adjudicative power of an arbitral tribunal and to admissibility as a concept dealing with the exercise of power and suitability of the claim brought pursuant to that power of adjudication. The conceptual distinction between jurisdiction and admissibility is not merely an exercise in linguistic hygiene pursuant to a pedantic hair-splitting endeavor. This distinction has significant practical import in investment treaty arbitration because a decision of the tribunal in respect of jurisdiction is reviewable by the supervisory courts at the seat of arbitration for non-ICSID arbitration or before an ICSID ad hoc committee pursuant to Article 52 of the ICSID Convention, whereas a decision of the tribunal and admissibility is not reviewable. See John Paulson, Jurisdiction and Admissibility in Global Reflection, International Law, Commerce and Dispute Resolution, so and so, so and so, so and so. Now, para 42, Manoj, the jurisdiction in Lesotho was followed in BBA versus Baz, wherein the Court of Appeal held that the statutory time bar goes towards admissibility. The court held that the tribunal versus claim test should be applied for the purpose of distinguishing whether an issue goes towards jurisdiction or admissibility. The tribunal versus claim test asks whether the objection is targeted at the tribunal in the sense that the claim should not be arbitrated due to defect or in omission to consent to arbitration, or at the claim in that the claim itself is defective and should not be raised at all. Applying the tribunal versus the claim test, a statutory time bar goes towards admissibility as it attacks the claim. It makes no difference whether applicable statute limitation is classified as substantive or procedural in the private international law sense. The issue of limitation which concerns admissibility of the claim must be decided by the arbitral tribunal, either as a preliminary issue or at the final stage after evidence is led by the parties. In a recent judgment delivered by a three-judge bench in Vidya Drolia so-and-so on the scope of power of Section 8 and 11, it has been held the court must undertake a primary first review to weed out manifestly ex facie, non-existent and invalid agreements or non-arbitrable clauses. The prima facie review at the reference stage is cut the deadwood where dismissal is barefaced and pellucid, and when on facts and law, the litigation must stop at the first stage. Only when the court is certain that no valid arbitration agreement exists or that the subject matter is not arbitrable, the reference may be refused. In
This
so
view,
yes,
judgment was considered in SBI General Insurance.
it was
To some
referred,
extent, in the reference.
and see also I think referred. But all of them have maintained this distinction, Manoj, the tribunal versus the claim test. They have
No. There is no dispute on these. Question is, assuming we segregate the claim test from the general limitation for assuming that yes, you are within limitation. For a referral court, is it that, or are we required to go and at least look into the basics?
That is where I was proceeding, Manoj. Of course, the tribunal, I'm sorry, this honorable court will look into that aspect provided, I think it has been very clearly said that there is no iota of doubt in the mind of this particular court that it is so ex facie barred by time that that claim cannot succeed at all.
To have that iota of doubt, we'll have to proceed.
Yes. Yes. Or it has to be so glaring on the face that it is so. It was a claim of 1984. I filed it in 2020. Perhaps something.
Some recollection that Prolia was also referred to SBI. General
I'll
Insurance.
check up on that. But SBI do not have.
Maybe this may not have been dealt with in some other issue.
I'll check up.
Now, what about the claims? You can tell us quickly. Your claims are in the year 2018 and be time barred after 3 years. And you have raised your first claim in 2023.
Oh, my lord, there also, first of all, Article 137 has no application there. So I'll just place one paragraph of that NTPC. 26 onwards, my lord. As a general rule and a principle, the arbitral tribunal is the preferred first authority to decide all questions of non-arbitrability. As an exception to the rule and rarely as a demurrer, the referral court may reject claims which are manifestly and ex face not arbitrable. Explaining the position following from the principles laid down in Vidyadrolya, this court in a subsequent decision in Nortel Network held while exercising jurisdiction under Section 11 as the judicial forum, the court may exercise the prima facie test to screen and knock down ex facie, meritless, frivolous, and dishonest litigations. Limited jurisdiction of courts would ensure expeditious and efficient disposal at the referral stage. At the referral stage, the court can interfere only when it is manifest that the claims are ex facie, time barred, and dead, or there is no subsisting dispute. The standard of scrutiny to examine the non-arbitrability of the claim is only prima facie. Referral courts must not undertake a full review of the contested facts. They must only confine to a primary first review and let facts speak for themselves. This also requires the court to examine whether the assertion on arbitrability is bona fide or not. The prima facie scrutiny of facts must lead to a clear conclusion that there is not even a vestige of doubt that the claim is not non-arbitrable. On the other hand, even if there is the slightest doubt, the rule is to refer the dispute to arbitration. Now, the doubt, that's why I wanted to refer to that COVID aspect, Manoj. That is perhaps one way of looking things which the tribunal tomorrow may endorse or not endorse, Manoj. But today, going by their calculation also, Manoj, it appears to be within time if we take into account the sort of exemptions that were granted to during COVID, Manoj. Manoj, insofar as that
your claims, your limitation for your claims start from which date?
From after 21 days from the date my RA bills are raised, according to the agreement.
It was raised on?
The table is at para
197, 198 of my.
Give us a tentative date.
2018, Manoj.
2018. So 2018 which month?
2018, April, July, and October.
So if we the July bill, then the claims your decision start from August.
Yes. Then it ends in August of 21.
21.
That's in the middle of COVID. And offshores has specifically taken this particular view. Offshore also, Malad, it was concerning that only. Paragraph 22, if your lordship has. In the present case, the final bill was raised by the appellant on 23/2018 and the amount became due on 21/4/2018. That is 30 days from the date of submission of bill as submitted by the appellant. The period of limitation to file an application under 11(6) of 1996 Act would start from 21/4/2018 and an application for appointment of arbitration ought to be filed within 3 years from such date, that is on or before 21/4/2021. However, the appellant has filed the arbitration case number so and so before the High Court on 15/3/2022, which is beyond the period of 3 years. In the normal course of action, the application filed by the appellant would have been hit by the statutory bar of 3 years. However, it is essential to refer to the order dated 10/1/22 in this court in cognizance of for extension of limitation, where a 3-judge bench of this court held that in view of COVID-19 pandemic period from so and so shall stand excluded for the purpose of limitation as may be prescribed under any general law or special laws in respect of all judicial or quasi-judicial proceeding, the relevant portions of the order, portion of which reads as so and so. So that perhaps your lordship has seen Para 24, thereafter, my lord, the above decision.
Yes.
The above decision came to be delivered by this court considering the hardship faced by the people during COVID-19. It would be unjust and detrimental not consider this while deciding upon the period of limitation in this present case. Therefore, the benefit of the period from 15/3/2020 to 28/2/2020 must be given to the appellant, and this period need to be excluded while counting the period of limitation for while.
So you claim to be covered under 5.1.
Yes.
What is the implication of 5.2?
5.2 also, if we calculate it by 5.2 also, consequently, the balance period of limitation remaining as on 3/10/2021, if any, shall become available with effect from 1/3/2022. We have done a conservative count as per this also, where we say that the limitation, the exemption will stop at a particular moment, and it's only the balance that would be available after 22. Then also we are covered.
And the respondents say that this is not applicable. Why?
Because the judgment says so.
I'll get that also.
At para number 4 of the judgment itself,
which judgment?
Of the Supreme Court suo motu.
Suo motu.
Yes, I have given a copy.
Yes.
Para number 4. Make your lordship.
Yes.
It is further clarified that the period from 15/3/2020 till 28/2/2000.
There are 4 of this 22 order.
Yes. Suo motu writ petition.
January 10/22.
Yes.
Para 4.
Para 4. Page number 4.
Para 4 is in page 2 of this. Okay, Roman 4.
It's Roman 4. It is further clarified that the period from 15/3/2020 till 28/2/2022 shall also stand excluded in computing the periods prescribed under section 23(4) and 29A of the Arbitration and Conciliation Act 1996, section 12A of the Commercial Courts Act 2015, and provisos B and C of the section 138 of the Negotiable Instrument Act 1881 and other laws which prescribe period of limitation for instituting proceedings, outer limits within which the court or tribunal can condone delay and termination of proceedings. Your Lordship, the notice comes under section 21. In the year 2021, October 2021 or July 2021, there was no restriction as such upon them to issue an arbitration notice. They cannot take the alibi of having a COVID existence for issuance of a notice, and it specifically outs the section 21 for its applicability.
So you say that as per this clause Roman 4,
yes,
the extension is only restricted to 20, 23 and 29 weeks.
Yes. Because the Supreme Court has specifically dealt with different laws and specifically pointed out the provisions under which this limitation exemption can be given.
To that, I'll answer 3 points. First of all, that list is not exhaustive. It clearly says or any other law which may provide for period of, so they just because some
interpretation rule has to be applied.
Exactly, which is precisely my point, mentioning of something would not mean exclusion of the other, because it also says any other law which provides for or institution of proceedings. That's number 1. And why have they mentioned 24(3) and 29A specifically, Manoj? Because 24(3) and 29A are the only sections in the Arbitration Act which are talking about specific time periods. One is when written proceedings or pleadings are to be complete, and the other when the arbitral proceedings itself have to be completed. So therefore, they were specifically spelled out. Now 21 doesn't really talk about limitation at all. 21 only says the proceedings would commence when you place the first request. Thirdly,
what are the other first orders which were passed, they're all sequel to the earlier order.
Correct. And that was general in nature, but I'll fetch them in this.
We also like to look into those. Anyway, so
And lastly, what they are urging is not a bar of limitation under the Arbitration Act. What they are urging is my claim is banned. So how will the claim be adjudged to be time barred or not? By virtue of the articles for payment of work done within 3 years when the work is complete. So those are governed by that schedule to the Limitation Act. Strictly speaking, they have not confined to a question, an argument of limitation as per the Arbitration Act. Because they're falling back on the question of limitation for the original claim, the substantive claim. So this particular observation made that it applies only, cannot be read as meaning it applies only for 23(4) and 29.
So that would depend on how the court conceived of
definitely.
Because extending the limitation by the first order. Why was there are several petitions filed?
Yes.
That point in time.
And ultimately for suits also they did not really specifically mention that these are the kind, because ultimately when I lodge the claim, it will be my original claim and it's a suit of sorts, just that the forum would be the arbitral tribunal. So for that, this particular paragraph can never come in the way. Had they said that had this been an application under 29A for extension of the period, then perhaps this paragraph would be relevant. For my friend has difficulty, can it be there?
Your Lordship, can it be?
Let us do one thing. Let us make an attempt to continue today after we complete the rest of the matters. Then we can decide. Next week we don't know because there are some matters fixed. What is convenient for you on Tuesday?
22nd, 17th. 17th is convenient.
17.
Yes.
Okay, let us have it on 17.
Let me. Sorry,
18th.
It's a hearing.
So hearing or no hearing makes no difference. Because we are continuing here.
18th.
Not on 16. 15, 16.
I'm traveling.
18th.
18th.
18th. This matter only. But please get the
COVID order.
the earlier
I'll
order
get that and
examine the SBI general report as to pass through this quickly.
Being the similar matters are fixed, but I'm not sure.
Another aspect, Lordship, is it's a regularization and pension matter. Finance.
What is your claim?
Here, my lord, I was appointed as a master rule, way back in January 1989. Then pursuant to the cabinet decision of 2005, since I was appointed prior to 1/4/1993, my name was stopped to be equal, but nearby due to a mistake on part of the respondent authorities, my name was omitted. In fact, a person was referred twice, and my name was struck off. My name was not considered. In the meantime,
What is the stand of the respondent?
they basically relied on
Upendas, my lord. Now Upendas is no more otherwise. And in fact, Nandi, my lord, in fact, my lord, the respondent authorities, my lord, took up my case. They even wrote to the authorities concerned. And ultimately, my lord, he was suffered.
Your husband worked as a master role.
Yes, ma'am. In the Department of Veterinary and Animal Husbandry Department. But it was a compulsory appointment. My father was a doctor earlier. Now, what has happened, my lord? He expired before his regulation.
Husband or father?
Husband, petitioner's husband.
Petitioner's husband.
My father-in-law, the petitioner's father-in-law was a doctor, and her husband was appointed on compulsory. So he was engaged as a master worker. Now, before the petitioner,
appointed as a under compassionate appointment, but not as a master role.
As a master role.
But compassionate should be regular appointment.
Exactly. So that is one aspect of the matter, my lord. Now, if your lordship, I'll just here, my lord, because of the fault on part of the authorities, my lord, I have been made to suffer. So lordship kindly takes up the Lord, here is an additional if it was filed, lordship will kindly come to that page 41. So page 42. These are admissions on their part. With reference to your letter dated so and so, I have the honor to inform that around 17 numbers of master workers of this establishment which was approved earlier, accordingly wages of 70 so and so was drawn since long time. Now, at the list of appointment letter which was received from you and so, it is found that Dipen Gogoi, this was my husband, master worker in this establishment has not included at that list through oversight. Mrs. Ronju Raskwa, master worker of the establishment of the subdivisional animal husbandry and so, was included in the list of the establishment initiated instead of Sri Dipen Gogoi, master worker. Therefore, I would like to request you to kindly make a arrangement to appoint Sri Dipen Gogoi, master worker at this establishment in place of Ronju Raskwa, as she has already been appointed against the establishment of subdivisional animal husbandry and so. So, Ronju Raskwa's name was referred twice. If I just take you to that document, you'll also will find it page 45. Whatever last serial number 17, Mrs. Ronju Raskwa. Now you'll also will see the master for the last part. She's a master worker under the animal so and so. Hojai.
You're reading what? Which page?
Page 44. The list without of
in the additional affidavit.
In the additional page 44. Running pages.
Your page numbers are corrected.
In fact, that was
page 44, list of master worker.
Yes, list of master worker.
45. List is at 45.
44 is the list of page 44 list of master workers.
Yes.
Lordship will see serial number at last part, Ronju Raskwa. My name is not there. While referring my name, but the days below my name was omitted.
No, my means?
My means with my husband's name, Dipen Gogoi's name. Now, Lordship will see Mrs. Ronju Raskwa at page 44, last one. And Lordship will see she was posted at Hojai. Last page, she is a master worker under so and so. Now, attached to the details so establishment of master so and so, Nogam. Now, Lordship will again come to page 46. So, her name was referred to as.
What you see is a type copy.
The type copies are at page of the reply. So, we come to page 79. This is the reply to the affidavit filed by the department.
$79.
78 is the regulation order, my lord, where, my lord, 923 posts
So
were
78 is a part of the affidavit in
Yes, my lord, it is also a part of the. Now 79, my lord, see 79 and 80, page 80. 79, your lordship will see at serial number 5. Lordship will kindly come to page 79. This is a list type copy of the list.
79 is the last part of the affidavit, declaration.
Here also in bit 106 is the list.
Is it an enclosure to the affidavit?
Affidavit in reply.
Affidavit in reply.
Reply.
Yes, affidavit in reply.
Lordship at Annexure 12, Lordship has the Roman 12. Start with. This is the, my lord, letter, my lord, for regularization. And the next page, you know, there is a type copy of the relevant extract.
Nine 23.
Yes, ma'am.
Now your name is not included.
Yes, ma'am.
Not included.
Not included. Lordship will see page 79.
Where is your initial order of appointment?
That, my lord. Yes, Lord, I entered it in the case the subsequent stage below, that is called page 15. The appointment order is not there, you know, but this is the paragraph, page 15, below annexure 1 is the circular regarding regularization with effect from 22/7.
Begins at type.
Lordship has got it. The Lordship will see at serial number 5. It is, my lord, beyond 1 so the 596 5 Ronju Rajkwa.
No, you are referring page number.
Lordship has seen the type copy. The
type copy, page number 15. This is the office order. You're referring to the office order.
No, office order, yes. Yes. This is a 15 is the circular regarding regulation. The
read out the date of the order.
That is 1st of October 2005.
2005, yes. Then where is the list?
Yes, my lord. Here the problem is
there is no list.
The documents, my lord, most of the documents were not with us. Now, what has happened, my lord? After the death, the wife approached the authorities. And for the first time, my lord, the lordship can even come to page 18. 18 is the representation, my lord. It was fine by the petitioner.
Stand on the respondent, their affidavit.
Since his name was not regularized, in view of Upenda's case, this case cannot be considered. What transpires from the record below in the affidavit, my lord, they also admit that it is on their fault.
Which paragraph?
Lordship, kindly turn to page number 49 of our affidavit, Lordship, paragraph 4. The petitioner joined as master road worker in January 1989 under establishment of Animal Husband and Veterinary Office, Nagaon, and continued till 2012, Lordship. Thereafter, he reported by the office Nagaon that he remained absent continuously in the office without permission. Later, he died in 2016. Till 2012 to 16, he was regularly absent without informing, without any due permission, Lordship. So, in that case, Lordship, with the other 13 MR employees of DES 2005, his name was not sent through for regularization at that time.
No, but where is his order of appointment? How was he appointed?
That is not on record, my lord. That my lord, the documents filed by the respondent, my lord, that is explicit. I'll just take you to Lord will kindly come to page 66. That is the document annexed to the affidavit, annexure 3. Pursuant to my representation, my lord,
You are referring to the affidavit.
affidavit.
63 is a part of Upendas.
Oh, yes, part of it will lordship annexure 3. Here the marking 66, paragraph page 66. Annexure 3, my lord. This is a letter dated 11/8/2023. Also will see with reference, this is with regard to the application filed by the petitioner regarding prior petition of so and so for fair consideration of justice done her husband in permanent appointment during his service tenure as well as the grant of facility from the department. With reference to so and so, I am to enclose here to forward here with the prayer petition along with encloses of by Sri Papamuni Gordule so and so XMR and request to submit detailed report whether his name was forwarded to this director at the time of regulation with effect from 2004-2005. Now, Lordship will kindly take note of the year. If forwarded, please furnish the details so and so. Now, Lordship will kindly come to the next page. This is a letter dated 22/9/2023. With reference to the letter number so and so, I have the honor to inform you that late Dipen Gogoi was working as MR worker under the establishment since January 1989 to 28/2/2012. So, 1989, so cut-off date was 1/4/93 as per the notification of OM of 2005. I was to be regularized. Now, lawsuit, what has happened? But at the time of regulation of service, his name was not included in the MR worker list of the then director so and so by the office dated so and so. Also, I'd like to state that as per this office letter dated so and so, Mr. DC Tambuli then is informed that the name of Dipen Gogoi MR worker of this establishment was not included through oversight. And Mrs. Ranju Raskwa, MR worker of so and so, was included in the list instead of Dipen Gogoi, MR worker. Similarly, there is an admitted fact that there were letters on part of the authorities, for which I have been compelled to suffer. The lawsuit will kindly come to the next page again, the letter dated 5/10/2005. So, had my name been regularized, I would otherwise have been entitled to pension. Now, this is a letter of 5/10/2005, with reference to the subjects letter on the subject cited above. I have the honor to inform you that there are 17 numbers of master workers of this establishment which was approved earlier. Accordingly, wages of 17 numbers of master workers was drawn since long time. Now, at the list of appointment letters which was received by from your end, it is found that the name of Sri Dipen Gogoi, master worker of this establishment, has not included that list through oversight. Mrs. Ranju Raskwa, master of the so and so, was included in the list of establishment instead of Dipen Gogoi so and so. Therefore, I would request you to kindly make an arrangement to appoint Sri Dipen Gogoi, master worker of this establishment in place of Ranju Raskwa, master worker, as she has already been appointed against the establishment of subdivisional animal so and so, Hojai. So, my lord, there was an initiative taken by the authorities for regularization. Well, this was of 2005. It was kept pending, and ultimately, my lord, from 2012 onwards, my husband was suffering from TB, my lord. In 2016, he died. The petitioner approached the authorities, nothing was done, my lord. Subsequent to which, my lord, she approached this honorable court.
Department have signed lordship till 2006. was not given that he was suffering from tuberculosis. From 2012, he was unauthorizedly absent in the department.
Well, subsequent issues, whether you are going to these services. Tell me, what, how was he appointed? According to the council, so the citizen is appointed on compassionate appointment. Compassionate, then it should have been.
Lordship, I can have for the initial appointment letter. Then, as it is not with the petitioner, I can ask for the department for the initial appointment letter. If time may be allowed, I will apply for the record, Lordship. For the initial appointment letter, it is not with the petition also. There is also not annexing it. Earlier also it was asked.
What is the direction in the Supreme Court?
Here, my lord. According to here. I just page 50, paragraph 54, my lord, I just without the relevant part. The appellants were left out of the excess of regulation owing to inadvertent mistakes, clerical errors, or administrative discrepancies on the part of the state. Hence, the appellants cannot be faulted for denial of the benefits flowing from the aforesaid cabinet decision under which nearly 30,000 similarly situated workers were regularized. So, my lord, here was not a case of irregular appointment. It was a the records will show, my lord, my father, the father-in-law was a doctor, my lord, compulsory appointment, so it had to be a regular appointment, my lord.
Where are you making this statement? It's there in the requisition.
Yes, it is a part of the, my lord, even a part of the annexure, my lord. They represent itself, and in fact, paragraph 2, my lord, the husband of the petitioner, last 3 lines. The husband of the petitioner has been working as a master employee till 2012 under a department. So that is admitted portion from 89 onwards. After this, due to being infected with TB disease, he died in the month of January 2016. During his service tenure, all the employees which were attached to the permanent post in 15th of August 2005 were able to get all the facilities from the government. But apart from the husband being deprived of all these facilities, after his death, she did not get any facility from your department. Moreover, the petitioner has come to know from the husband and his accompanying employee that at that time, due to the mistake of an employee named Saranga Bora of so and so, was deprived of his permanent appointment. He said that by some mistake of his name has been left out to that permanent list.
Where is the statement that your initial appointment was compassionate ground?
So that my lord, that statement directly is not there, but at the same time, my lord, should be at page 18. That is in the representation itself.
Alternatively, you have already, state has already admitted that this is
yes,
by oversight.
Yes.
Why don't you take steps to now get it regularized? Veterinary council.
It was a compassionate appointment. In annexure 2 also, page number 18, it is not written as it was a
All right, let us assume that he was appointed as some master road worker. Your affidavit, the communications exchange, we have admitted that he was left out.
So left out in 2000.
Left out, then steps should be taken to make the necessary correction.
That only appointment letter. Plus, another aspect is that there is not the finance as a party, finance or AD.
So finance will come only when you take some steps. You have not initiated anything.
1 week time will be allowed to for appointment letter. I not want the appointment letter.
Just after a week, enabling the coming down to complete the instructions with regard to the manner in which the electors came to be appointed. Her husband. Manner in which the husband of the state husband of the petitioner be appointed. Submission of the council. Her late husband. Just after 1 week.
An application for appointment of arbitrator. Since the petitioner was awarded both contract by the respondent, Lordship, the contract was extended from time to time and it was terminated in the month of May 2025. Thereafter, we issued a notice, arbitration notice, that is at page 225, Lordship.
Where is the arbitration clause?
Arbitration clause, Lordship, at page 63. The 11th portion, Lordship, at page 64. May I read it? In the event of any dispute or differences between, Lordship, demand for arbitration. In the event of any dispute or differences between the parties hereto as to the construction or operation of this contract or the respective rights and liability of the parties or on any matter in question, dispute or differences on any account or has to be withholding by the railway of any certificate to which the contractor may claim to be entitled to, or if the railway fails to make a decision within 120 days, then and in any such cases, but except in any of the exempted matters referred to in clause 63 of these conditions, the contractor after 120 days but within 180 days of his presentation his final claim on disputed matters shall demand in writing that the dispute or differences be referred to arbitration. So we wrote a letter to them that since they are
Page number?
Page 225.
The subsequent notice.
Lordship.
Where is the first notice?
First notice, Lordship, at page 219. 219. Lordship, thereafter, since the claim was beyond 20% of the contract value, they gave a reply that since the claim is more than 20% of the contract value, arbitration is not permissible under the contract. Accordingly, we issued a fresh notice reducing our claim within the 20% of the.
How is that permissible?
Lordship, the all damages compensation because we want early adjudication, so we have reduced it to.
You raise a demand.
Correct.
Issue a notice. And on being objected that it is more than 20%, you issue a fresh notice reducing the demand.
We have forego the damages and compensation. Otherwise, all receivables are there, Lordship. Only to that extent, we have enclosed that notice also. So only to that extent it was reduced because we want early adjudications.
When was the first notice issued?
First notice was issued on 16th of June 2025.
16th June.
Lordship. Page 219.
Yes, respondent, what do you say?
Appointed number. Oh, but there is a dispute, all other pleas will be taken.
Sole arbitrator.
Lordship.
That, my lord, perhaps the quantum.
What is the quantum?
17 crore, Lordship. 17 crore 84 lakh.
Big arbitrator.
How?
Page 64, my lord. Clause 64.3A1. But in case where the total value of all claims in question added together does not exceed 10 lakh
64.3A
Roman 1. Second paragraph. Case where the total value of all claims in question added together does not exceed 10 lakhs, the arbitral tribunal shall consist of a sole arbitrator who shall be a gazetted officer of railway or below. A grade nominated by the manager, sole arbitrator shall be appointed within 60 days from the date of when a written valid demand of arbitration is whether case not covered by clause 63A1. The appellate tribunal shall consist of panel of 3 gazetted railway officers not below the administrative grade or gazette officer not below the grade, and a retired railway officer retired not below the rank of SHG officer as arbitrators. In case of claim by more than 10 lakhs,
Section 12(5). Lordship, in view of Section 12(5) of the Amendment Arbitration Act, so the railway are interested in the subject matter of the dispute, so they cannot be arbitrated and they cannot appoint an arbitrator. Lordship. That if they consent, a sole arbitrator may be appointed.
By section 10 of the Arbitration Act.
find a number of
10(2).
But here the contract provides for
Provide, but they did not waive their right. So there is no agreement on the number of the arbitrator. Technically.
here there is a the contract, there is a clause. Clause 10, my lord, the party. There is no agreement to that effect.
When you arbitrator?
No, no, sir. We, in our notice, we stated that we'll file application under 11(6) for appointment of sole arbitrator.
Under the contract act, you were supposed to nominate your arbitrator. It is entirely left to the railways.
Since under the contract, it was left to the railways, but since we have not waived under section 12(5), so we straightaway wrote that we want to appoint sole arbitrator and we file application under 11(6).
provided, they 12.5 unless they accept.
That is in terms of code, that central code,
Yes.
they are ineligible. But the entire clause does not get.
It does not, but effectively, how is it be implemented unless you terminate your arbitrator? It's not done so upon a notice being issued. It's not nominated. Even your arbitrator is not nominated.
But the intent of the clause is in case of more than 10 lakhs.
Right. Intent is all right, but you have to give a reason why nomination is not made. But they have not made it, but you have to explain that why your officers were not, why did you not propose the name of the officer?
Order, my lord, held in a similar action, my lord.
Bring it.
Arbitration petition 20 of 5.
Under the contract, all the three arbitrators will be from the railways. So in our notice at page 227, last paragraph, we specifically stated that for appointment of a sole arbitrator. Because in the, as per the contract, we were not supposed to nominate anyone. It was not like that we will be appointing somebody, they will be appointing, and railway will appoint the umpire.
Which paragraph?
Paragraph 4, my lord. By the petitioner that as per clause 64 of the GCC, the event of disputes arising between the parties and the respondents and which requires resolution through arbitration, the provisions of section 64 are required to be followed. In terms of clause 64 3A, where the total value of all claims question does not exceed 10 lakhs, the arbitral tribunal consists of a sole arbitrator and who shall be a gazetted officer of the railway not below the J grade. the same language. Clause 63 therefore contains detailed procedure for the appointment of arbitrator. But in paragraph 5, according to the petitioner pursuant to the amendment brought into the Arbitration Act 96, the requirement of the mandate of section 12 is to be profusely followed. It is submitted that in view of the provisions of 12.5 of the 96 Act and the conditions made therein, the provisions of clause 63, 343A1 and 343A2 no longer be considered to be effective and binding. Therefore, petitioner by letter dated 9/2/24 proceeded to nominate the arbiter by nominating Justice T. Padmanabhan, former judge of Gujarat High Court, as arbitrator nominated by the contractor, and called upon the railway authorities to nominate their arbitrator. Once the railways nominate their arbitrator, two arbitrators will appoint the deciding arbitrator or umpire. Thereafter, paragraph 7, since there was no response, the petitioner approached the court under 11.6. Paragraph 26, accordingly, the panel of 3 arbitrators was appointed.
Because the issue here was non-arbitrability of the issue, whether it should be looked into at the stage of 11.6. That was rejected.
Yes, that was rejected. Left
but the 3 arbitrators are there because they had already been nominated.
No, they sent the request, but one name was suggested.
One names were suggested. One for the claimants, one for the railway. So these names are already there. It is not concurred upon. Therefore, the court appointed the umpire and confirmed the appointment of the arbitrator. The contract agreement number CON/capital J-I/1248 dated instruction of page 29. No? Contract was terminated.
No.
Subsequently, however, the contract came parties and where is your first letter?
First letter, page 219.
16/6/2025. clear communication. Six. Stated that claim as the read with 16.3 as the work order. The work was not for arbitration settlement. Thereafter. Hereby. Except the claim for damages and compensation. And thereby, the claim to the petition 17,84,62,717, which is less than 20%. The contract rate 9,028. On the three 64 within bracket three bracket bracket that's 64 bracket bracket small a bracket where the claim does not exceed, where the claim does not exceed 10 lakhs. The arbitral tribunal consists of a sole arbitrator, but presently it exceeds 10 lakhs. The arbitral tribunal is to be comprised of 3 arbitrators. However, submit that as per clause 60, bracket 3, bracket A, bracket clause provides for appointment of the arbitrator by the regulator. Submit that in turn be provide any express agreement in writing. By waiving 64 bracket 3 bracket E bracket 3. The bird under seven schedule. Additional filing. That. Clauses typically provide for appointment of arbitrators by the venue. Express waiver in writing regarding appointment of the arbitrators by the review. Their panel from their panel of observers as is required under section 12.5. From the things that one being called upon the by and between the parties. Second, parties are also permitted to furnish a copy of this order.
Item 31, same man.
31.
31.
31, somebody took time.
So I think inadvertently it has been written, but both of us has not. It matters.
CCC had taken time.
But every dates are also same.
Just give us the dates of contract and the notices, etc., which are there. Furnish it to the court master. That's it. These both matters only. Second,
Much of it.
order to mark.
It is suspension matter now put on. Appeal light manner. Against it.
It lies where you have to file some affidavit.
We have filed affidavit. Why affidavit is filed here?
Affidavit is filed.
Huh?
On 25th May,
File.
filed. It is available, I think.
Matter after 2 weeks.
Right.
Lordship, my senior SK meeting is on late. Lordship, can this matter be fixed on some other day?
Person was appointed as a constable in CISF. That his services were terminated.
Termination of service. Pleading the exchange.
Really exchange.
Rule for the record.
No, Lordship, because I'm already, there is no stay over it. Right? There is no stay.
You are terminated.
I understand. So,
What difference does it make stay order or not stay?
no, no. Since I'm already not in service, that is what.
Yes.
Lordship, fix it on 23rd.
Oh, come after me. Hearing in the month of August. Come. Part 2 hearing. The last day of the yeah, because the record will be necessary.
Records, otherwise okay. Records otherwise not necessary.
Why?
Because the main concern that I had made a false declaration. Ground of rejection was that I made a false declaration. That is not the case. Here it was a case, where I'm a resident of the state of Assam. While sending the PRC, the police revision was done, they found me a resident. I was born and brought up here. Last 3 generations I'm here. The only thing, while the inquiry was being made prior to my final probation period, expired the probation period, they came to know, that one line was added that they originally hails from Bihar and is living in a rented house. Only because I was living in a rented house and my forefathers belong to Bihar, I was terminated for making a conflict. So I presented before them authorities. In fact, the appeal was also filed before the authorities. That is against the law. That is understood. They could not have done it because the domicile is something different. They say I have to be citizen of India. I'm having a domicile. Since 1969, my forefathers had my grandfather. I had produced all documents, my birth certificate, PRC, everything.
What is that false statement?
False statement that I stated that I'm a resident of Assam. The false statement is that my forefathers originally belong to Bihar. That is the false statement. As per their claim.
Examine.
I not condition last order my affidavit for respondent. Fine.
To file. The affidavit is required.
1 to 4, my lord. 1 to 4.
1 to 4. 1 to 4. 1 to 4.
1 to 4, Madam Director.
Are you filing your affidavit or not?
No, Madam, we have already filed an affidavit, respond of 5.
Respond 5.
5, so 5 enough.
Enough.
Enough, Madam. So it is a ballot. Right.
You have filed your response. Reply.
My lord, I have already filed on
Reply file.
and record was called as the last one.
What is your claim here?
Same year, my lord, this petition has been filed against the dismissal of that.
Where is the order of dismissal?
Page number 12, my lord. Piece of the findings submitted by series so and so.
I agree with the finding of submitted head constable Prasinga is hereby dismissed from service for his indiscipline act and gross misconduct during execution of duty, which are not acceptable from.
Where are the findings of the inquiry officer?
I think, my lord, page number 30, my lord.
Appeal file.
Appeal has been filed, my lord, has also been rejected, my lord. That 500, he has not received the rupees 500, my lord. Rupees 500 received by some other police persons as a fine, my lord. My statement is at page number 29, my lord.
You are demanding some money.
500 rupees has been received by some other constable, my lord, as a fine from the truck driver and deposited to me, my lord. And I have already deposited to the treasury, my lord. But the allegation, the video clip is that we have taken the bribe from the truck driver, my lord. That's why my lord has passed the order, while issued a notice, my lord. God was called, my lord, the first time, my lord. That was not notice. Inquiry, my lord, I have already stated that head constable Junaid Hussain has received the money as a fine. But they have not used the belt, my lord.
Are you authorized to collect fine? Fine for what?
For not near the seat belt, man. Not near the seat belt, man. Their affidavit, my lord, they have already stated in it. 10th occasion, the fine and be posted to your place.
Where is that receipt?
Receipt, my lord, as per the petition, one receipt has been deposited at treasury, my lord. Not with the petitioner, my lord.
Maybe who deposited?
Receipt cannot be.
Who deposited?
Sorry, my lord, amount has been deposited to treasury and receipt has been deposited to office, my lord. Who deposited? That fine amount has been by the petitioner, my lord.
When? Which day? Your statement before the inquiry officer did not make any such statement. Where is your WS? Where is your WS?
My lord, kindly see page number 24 and excerpt 4, my lord.
This is not your WS.
Reply to the so-called notice.
This is reply to the so-called notice.
Yes, ma'am.
Now the question is that according to you, you have issued receipt. You have issued receipt.
My lord.
You have issued or you have asked somebody to issue give a receipt.
My lord, some other home guard person has collected 500 rupees from the truck driver and deposited to me, my lord.
So did you give a receipt for that?
Yes, my lord. I have given the slip, but the office record, my lord. That book of receipt, my lord, he has deposited the office, my lord.
Then why were you present during before the inquiry officer? When the examination took place of the witnesses?
My lord.
You were there.
My lord. I have stated, my lord, in my inquiry, my lord. Page number
29.
29. And,
yes.
And 28, my lord, that is the person, Nel Hussain, who has collected the 500 rupees. Page number 20 at bottom, my lord. Head Constable Rudra Singh, Vasudev Burman, and accompanied him were detailed for Naka checking.
Where have you made the statement that you had issued a receipt?
So,
not there.
when he was asked by the inquiry officer to process the fine realized receipt.
You did not want to cross-examine the witnesses.
He has not defense witness and records witness.
See my note page number 14 of the petition order, paragraph number 9. Start from the fine book public record was no longer in its possession. Page number 15, my lord. In its defense, and it was the duty of the department to verify if such entries are made or not before proceeding against it. Developed clip in social media does not reveal any detail about the conversation, public reason for which the money was collected, and the same thereof cannot be used on conclusive evidence of acceptance of bribe. Draft number 20 that I have submitted that
These are all afterthoughts in your appeal memo also. All these issues were not raised with the appellate authority. That you deposited, it is there in the department, it has been deposited in the treasury. And your statement that this particular,
He only denied about a viral video. That is not a genuine.
your statement, even if we accept that the very basis of query on the basis of video is correct, or was not decided, you admitted that you have correct. By someone given to you. There is no statement before the inquiry officer that you had entered it. The receipt book, given a receipt, nothing like that. You had said that the amount was collected, handed over to you, handed over back to the person who deposited in the treasury.
What is necessary, my lord? That's why.
For what purpose?
Only for that, my lord, that receipt that I have deposited to the office.
You have not even given the statement.
No statement, my lord.
In your, before the inquiry officer, nothing. Before the appellate authority, nothing. Yes, records.
But this is the admitted fact, my lord. He realized that.
Why don't you get the records instead of arguing here? We can go to the records.
My lord, I have to verify, my lord.
The records pertaining to the departmental proceeding are placed before the court after
weeks, my lord. Okay.
On 4th of August. They will be made to dispose of the matter.
Thank you, Lord.
Meg. per last order, they supposed to file the affidavit, but they have not filed it. As per last order.
My lord, there has been a decision, my lord, yesterday by a coordinate bench, my lord, in 3157 of 2022, my lord. The judgment is yet to be uploaded, my lord. It basically talks about setting aside of Upen Das, my lord, and now as per the new Supreme Court judgment, my lord, it allows the petitioner's claims to be verified and accordingly pension to be paid. So, if Lordship fixes it on Friday, my lord, I will place that order.
Monday.
Monday.
This is the master roll worker.
Yes.
Submitted that decision in the High Court based on the pursuant to the judgment of or taking into account
Sukhendu Bhattacharya.
Sukhendu Bhattacharya reported in 2012. However, say the judgment of submitted that matter be listed again. Monday. The counsel for the respondent will please be very same. Prayer made is also get by the counsel.
Public.
And please, Lordship, in this matter, record directed to place the record, Lordship. That record is not received. Some more time required, Lordship.
Karim Ali judgment.
Single
Where is
judgment
it?
here.
Where is it? The copy placed before the court. Huh? Where is it? Not here. Why is it get? Why the judgments are not available in the court file? I don't know. What is this Karim Ali? Quoted in 2020, volume 4. Where is, do you have a copy? Give it to us. Karim Ali.
On that.
You know, submitted, but it is not here. Unless put the judgment.
Single judgment.
according to you, the view of the Mother was
Consider.
not considered.
Yes, my lord.
As far as in your favor.
Yes. Rely on the Rajeshwar Das, my lord.
But this Karim Ali judgment also says that after amendment,
Yes,
provides the requirement of giving preference to the family.
yes, as per notice.
Only
preference.
Huh?
Only preference will be. But it's clear from that judgment.
No, in the requirement of obtaining the view of the Mozada.
That is proceed in conjunction with the preference.
Is the meaning of that?
One question of preference will come, then question of obtaining the.
How?
Yes,
How?
that's what that.
Preference is to be given on what basis, Mr. Doctor?
Yes.
Preference.
Equal mark.
No. Preference. What is the basis for giving the preference?
Yeah, the family member, he should have belonging from a family member.
Family. And what about the opinion of the Mother?
If other,
what extent?
all categories are fulfilled, then opinion of the Mother is considered.
Opinion of the Mother is to what effect?
Maybe
What will the opinion be rendered? What context is the opinion being rendered?
the groundwork are important from the same law clause.
Huh?
The residential status and their properties that they have so to some extent
It has got nothing to do with whether saying that it belongs to the Gambura family. That Zada's opinion will not contain that.
As per my lord, the division bench and the judgment passed by the Bishop Bushaman, the preference Mozadar view and the family member.
Which judgment you are relying?
My lord, I rely only the my lord Rajeshwar Das, division bench judgment.
That is to be read with condor pro forma.
Yes, Lord, it has been said that.
And now Keshav Bush, my lord.
That is it. Case of Bush. So
Yes, my lord. My lord. Here, this my lord condition is the.
Where is the judgment? Which paragraph?
I'm sorry.
Only one copy.
My lord, I'm sorry, my lord. Okay. Clearly stated when the petitioner selected, three categories will be fulfilled. On the family and the Mozudar, whether Mozudar report means whether the person is suitable for the post of the homeowner is recommended, my lord. If the Mozudar recommended the person who applied for the post and he is suitable and he will request it to the deputy commissioner, the person is suitable, so he may be appointed, my lord. That is the view of the Mozudar. In respect to my case, my lord, the Mozudar especially requested to the deputy commissioner, the person is suitable person, so he should to allow to appointed, my lord. But in the case, my lord, the judgment in appeal, my lord, only that part is not considered, and my mark and the private respondent mark only 0.33 is different, my lord. If some mark is given, I will be highest, my lord. Kindly, my lord, see page 62, my lord. The difference mark, my lord.
What is your name?
My name, my lord. My lord, Faizul Haq.
Faizul Haq.
Yes, my lord.
You are the appellant before the authority.
Yes, my lord.
What was the order passed here?
my lord, dismiss my request on the basis of the merit, my lord. But on the view of the Mojadar, that part not consider, my lord. And the only merit is when merit in the that we obtain the mark, the Mojadar column. That
Now against this, there is a review.
Yes, sir.
You have not filed a review.
I am not filed any review, my lord. But there is no bar, my lord. Number of cases disposed is by the honorable court, and your lordship also passed the number of cases, my lord.
As per division bench order, lordship, there is none. As per division bench order.
Umeopolita decision, my lord, he has not appeared before the appellate authority, my lord. Directly approached this honorable high court, my lord. So that is the why, my lord. But I have approached the appellate authority, my lord. Omeo case is the difference, my lord. This is not applicable in this case, my lord. The Omeo case, my lord, the petition approached the honorable court without filing the appeal, my lord. He approached directly the high courts, my lord. So that is not maintainable, that part, my lord. But here the case, my lord, I am admitting, my lord, there is part of the
who has obtained more marks?
My lord, as per report, my lord, the petition I have got. So your lordship, last August on directed to the relevant record the mark. The petitioner and the respondent gets mark. I collect my photocopy, my lord. The petitioner gets, my lord, respondent number gets, my lord, 18.00 mark, and I, my lord, the petitioner 17.67 mark. Only 0.33 marks less. I get only 0.33 marks, my lord. On the basis of these marks, my lord, the private respondent was appointed. But in the content by my humble submission, my lord, the mark in the Mojadar view, that is not considered at all, my lord. So if some mark is allotted, my lord, 1 mark, 2 mark, any mark, my lord, in respect of the view of the Mojadar, the petitioner will be get more mark than, my lord, the private respondent, my lord. So your lordship in the last occasion, your lordship heard this matter and directed the deputy commissioner and Nalbari to produce the relevant report. Today, for the reports,
records are here. Now,
here,
what is the finding? What is the conclusion of the this judgment? Case of Bushso. What is case of Bushso?
Case of Bushso, my lord, the point. Actually, para number I forget, my lord. The case of Bushso judgment is depiction in law on the basis of the mark should some Mojadar view and family support, my lord. That mark was not considered. And the basis of the merit, petitioner shall not be selected, my lord. On that part, my lord.
Yes, 62 lordship. 5 marks was given to the petitioner, extra 5 on preferential basis. So it is considered lordship.
That
page
part
60,
is
page 62 lordship.
that part. But value of the Mojadar never considered, my lord.
There is no provision for marks of the Mojadar.
Yes.
There is no provision.
Yes.
Where under the who conducts the inquiry? I mean the selection.
Deputy Commissioner Chairman.
Deputy Commissioner.
Yes, ma'am.
What are the heads under which the marks are to be issued?
As per notification,
Is it specified in the advertisement?
it is in notification lordship 10 for 2018 lordship.
Where
Case
is it?
80 of my opposition lordship.
80.
80. Selection board lordship. Then below portion, the selection committee shall essentially assess the leadership qualities and candidates along with her ability to inspire people and to lead a law-abiding and value-based life. The division the areas shall make the police verification report. Except this, there is no mention lordship regarding marks.
We'll get the records then. Why the records are not being given? Huh? Why have they not come? We have called for the record because nobody is able to explain the manner in which the markings are to be granted. Is it available in some OM notification? Show it to us. By the earlier order, dated 13/5/2026, the State Council was directed to produce a record, selection records, available in the office of the Deputy Commissioner. However, MS submits the records are not available. Records are necessary to understand manner how the selection marking which were allotted to the heads under which the marking. Let this matter be listed again. In July 22nd July.
Hello.
There's Laura for date. Huh? 21st. Judgment get a copy code. Yes, item 39.
Petitioner has challenged the order dated 18/11/2025. You will find it page 34 of my petition. A termination order. He was in probation, but the termination order is purely punitive in nature, and it was passed on the allegation of misconduct without adhering to the rules as per Rule 9 of the Assam Services and Discipline and Appeal. And in fact, in their affidavit in opposition, they have admitted that no DP was conducted.
Some inquiry was held.
Yes, that inquiry is not sufficient.
DP cannot be held because the rules are not applicable. You are on probation.
Lordship,
You're on probation.
Your Lordship may kindly see the language of the unit. Para number 5. And whereas the inquiry committee, after completing the proceedings as per rules, has held Sri Thapa guilty of misconduct and recommended that he be dismissed from government service. So once he is guilty of a misconduct, whether he is in probation or a confirmed employee, the rules has to be followed. A proper DP has to be conducted.
So in this matter, I have filed my affidavit, Lordship. I have taken a specific stand, Lordship. And I find, Lordship, the petitioner has not yet signed their reply.
What is your stand in the affidavit?
That is the stand, Lordship.
Then
During the
no
probation.
no DP was conducted. That is their stand. Because they say that there was no experienced person in their department. It's a newly created division, and therefore they could not conduct.
During the probation period, Lordship, the person concerned was arrested in a criminal case, Lordship. A committee was constituted. As per the committee report, Lordship, we was serving.
But you are conducted it under Rule 9.
Yes, affidavits. Today, Lordship, my simple prayer will be, Lordship, if he is not filing any, rejoin their Lordship, then let this matter come up for hearing. We'll record that he is not filing it.
That reply is not necessary because in my petition I have dealt with all the.
That situation you are
No,
not
what is your grievance?
My grievance is that Lordship, since they alleged misconduct, whether he is a permanent employee or
they have conducted under the.
No, that will not be sufficient.
What is sufficient?
I'll take your Lordship to page 30. I am taking to your Lordship to page 30. 30.
Yes.
He was, I'll just place the facts. On 22nd of May 2023, he was appointed in a grade 4 post, and then he was posted at the office of the executive engineer, and thereafter he was employed at the office of the deputy commissioner, Tinsukia. And then again he was released, and on 16/6/2023, he was arrested and he was placed under suspension with immediate effect. Thereafter, he approached this honorable court since no subsistence allowance was released. During the pendency of that writ petition, subsistence allowance were released, and then this letter was issued on 4/10/2025. Your Lordship will kindly see the last paragraph. In this regard, in view of the ongoing, as your Lordship got,
Paragraph.
page 30, last paragraph. In this regard, in view of the ongoing Hamren PS case number 14 of 2023, and for the purpose of reviewing your suspension, an inquiry committee has been constituted under this division. Therefore, you are directed to appear before the said committee on 14th October 2025 and submit a written justification explaining the reason for your arrest and furnish the details and present status of the police case and valid grounds, if any, as to why your suspension should be revoked before the inquiry committee to facilitate the inquiry process without fail. So, by letter dated 4/10/2025, the petitioner was asked to furnish explanation as to why his suspension should be revoked. And upon furnishing of that explanation on 14/10/2025, that he was not, he was falsely implicated in the case and arrested falsely. Page 32, your Lordship will find this in vernacular.
There is no inquiry held.
No, they say that you furnish your reply as to why your suspension should not be revoked. And once he replied in terms of the letter dated 4/10/2025, they passed the impeachment order. And they say in their affidavit in opposition, paragraph number 12, Lordship, of the affidavit. They say you are guilty of misconduct without affording me any opportunity, without affording, without framing the charges, without furnishing me the documents which are part of the inquiry. Nothing has been done. And they say they followed the procedure in terms of the Assam Services and Discipline and Appeal. Now, whether the law is very settled, your Lordship is well aware that once you allege misconduct, you cannot just terminate me without affording me an opportunity and without conducting a proper DP. Had it been a case of termination simpliciter, I could have understand that they can terminate me.
Well, you have to show us that the inquiry was conducted, because you have admitted in your affidavit that it is under Rule 9.
Not say that under Rule 9, by following the procedure under Rule.
What is the difference?
The language is same.
Required procedure prescribed under
Terminated
Rule 9.
after duly following the required procedure prescribed under Rule 9.
What is the meaning? Why will you follow the procedure prescribed?
So that is what I am submitting. If he is not filing his reply, Lordship will take up this matter ultimately for hearing.
What is there to be heard? You have to show us from the records that what procedure was followed. Because
In fact, on last date, I think Lordship, a prayer was
just
made
para
from
number
the
12.
respondent side. I mean, our side, not. What is the record? That record is also not. I think it is.
In fact, I claim that the records may not be necessary in view of their admission in para number 12 and 13 of their affidavit. At page number 39 and page number 40. May I read, Lordship, para number 2? That with regard to the statement made in para number 10, paragraph number 10 and 11 of the writ petition, the answering deponent begs to state that this office consulted the concerned officials of CE, that is Chief Engineer, PWD building, and the office of the DC Tinsukia, and the entire procedure of the disciplinary committee in this matter was guided by these two officers. Since the place of occurrence was the election branch of the office of the DC, this office had no access to examine any witness, and as such, no witness could be made available for any type of examination by the said government servant, namely Deepak Thapa. All documentary evidence was seized by Hamren Police, and based on these documents, a charge sheet was issued by Hamren Police Station wherein the said government servant, namely Deepak Thapa, was charged as an accused. Accordingly, the departmental proceeding had to be conducted on the basis of the said charge sheet prepared by the Hamden Police and the reply submitted by the said government employee, namely Deepak Thapa, to the show cause notice served upon him. However, it is admitted that although this division tried its best to conduct the DP as per the prescribed procedure, some procedural lapses might have occurred inadvertently due to the fact that this is a new division created on 1/12/2021 and the majority of its staff were recruited in the year 2023. As a result, no experienced person were available to handle such DP and court-related cases. Now, just because they do not have experienced person, they deprive me of my fundamental right to have a departmental proceeding.
And no witness was there
Yes.
and no documents. Mr. Nayak,
Lordship.
the immediate admission
Lordship,
of
kindly see the order dated 1st of June now.
first of the records are there, but
Yes, let me
in,
have
in
that
view of
record.
this clear admission, what will the records reveal? There was no inquiry in terms of the procedure
It is there,
conducted.
Lordship, because on the basis of the, police report.
Lordship, what the record will reveal is also there in paragraph number 30 of their affidavit of position. May I read that, Lordship? That with regard to the statement made in paragraph number 12 and 13 of the writ petition, the answering deponent begs to state that since the place of the said crime was at election branch office of the DC Tinsukia, the undersigned along with his staff had made DC Tinsukia for his guidance at his chamber, and accordingly Sri Pankaj Somua, the then ADC, personnel and Nazar branch of the DC office was contacted along with his staff dealing with court cases, etc., and also the officials of the election branch office of the DC Tinsukia. During the discussion with the above officials, it was clearly observed that. So this is 1 and 2. This is what they said in their affidavit of opposition. And lastly, they say that this strongly indicates the involvement of the state government servant, namely Deepak Thapa. So they held me guilty without providing me any opportunity. They did not frame the charges. They did not provide me the statement of allegations. They, in fact, did not provide me the copy of the charge sheet, which is part of the inquiry committee, which held me guilty of misconduct. And they terminated me. Had it been a case of simple...
there is some criminal matter pending.
Yes.
What is the stage?
That is at the stage of appearance. We have filed a discharge application. Probably that is...
Get the records heard from the parties for further the respondent to file their affidavit. Records pertaining to the inquiry conducted against the petitioner terminated. By who is to produce the records?
The executive engineer,
The disciplinary.
The disciplinary authority.
Executive engineer.
Records be placed by the executive engineer.
They did be filed by the chief engineer league.
Huh?
Chief engineer building.
But termination is by executive.
Not.
Yeah. Territorial building. Yeah. Chief engineer. The next date of listing.
May play for a date or after vacation.
Immediately after vacation. On 16, 17.
16.
All right. May I pray for an observation that an MBBS had been made by the...
The record there.
That's all right.
7 are similar. And in all the cases, respondents have filed affidavit also. Sometime may be granted to file reply.
Mr. Anand comes in that permitted to file their affidavit filed by the respondent. Right. Again, after 3 weeks. Which are the matters?
45, 46, and 47.
Item 40.
40, 45, 46, 47.
40, 45, 46,
47.
47.
Intermediate continuity.
It listed whether interim order is any. We get also see for the respondent and next report for. That's appearing. You're also CGC. That give the to the court master. Yeah.
In 40 and 40,
You give the name, give the list to the court master accordingly the name.
Item number 44 is also similar.
44 also. MS. AK Das.
PP does.
PP Das. PP Das. Okay.
What? So the petitioner was rejected by the review medical board on the ground of high BP lordship. They have filed their affidavit in opposition wherein they have annexed the specialist report lordship. Only thing that remains is lordship, that report is not as per the guidelines.
Where is that report?
The report is, your lordship will find the report at page 81 of their affidavit. So 5.
Is there any material to show that after this you are having regular BP?
No, lordship, we are not.
Why should it be disbelieved?
Lordship, no. I'm not saying I'm disbelieving this. Only thing that remains is lordship. If your lordship for a moment comes to page 40 of the report. Page 43, lordship. 43, 7E, lordship. Clause 7, subclause E. Lordship, may I read, lordship? For candidates who have been rejected on the ground of hypertension, tachycardia should be admitted hospitalized by the board. They have done that. Before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in blood pressure is of transient nature due to excitement, etc., or whether it is due to any organic disease.
So that we examine provided you bring some material to say that immediately on that day or 1 or 2 days later.
Yeah. Thereafter, lordship, he has annexed. We have annexed that report, lordship. That your lordship will find at page 38 and 39 of the repetition, lordship.
38, 39.
So,
Right.
38 is the type copy, 39 is given by Registrar of Department of Medicine, Kokrajhar Medical College and Hospital. There it was given patient is normotensive, BP 120 by 80. This was after their report.
Yes.
Yeah, so he was admitted in the hospital, lordship, and all tests has also done, lordship.
No, but
is the
BP,
extra,
BP, you'll have to examine it for a course of days. Just one instance of recording. How does one decide? This is what your rules say.
Yes, Lordship, all test has been done, Lordship.
Where are the reports?
Yeah, it is, I have annexed it on our affidavit, Lordship, page 72.
The,
Yes, Lordship, ECG report is there, Lordship,
no,
and
first you find out the guidelines. What does it say? Guideline.
yes, Lordship.
Decca, where is it?
Lordship,
The guidelines. as to
Guidelines,
how
Lordship
it
will
is to be
find-
undertaken.
yes, Lordship, that is at page 40, 43. 43 relevant page. 7
43.
subclause E.
That following examples are cited of the guideline of review medical book, and examples are admitted and hospitalized by the board before giving their final opinion regarding the candidate's fitness or other. He was admitted and his BP was found higher than required limit. X-ray also done. CG also done. First day, BP was found 176 and 90.
73.
76 and 90. In
29/11. His date of discharge.
yes, Lordship.
Date of
And
admission,
28/11 on
28/11.
page number 40, 28/11. 9 AM 140 90. 11 AM 144 90.
Page number
40 of our affidavit. 74 of our affidavit. Sorry.
done.
Yes, Lordship. Then all test was done. Lipid profile done. LFT done. Blood sugar done. ECG done. Also.
Done.
Done, but that Lordship, that specialist opinion should be from government medical college.
No,
Wait.
Lordship, there.
It's, it's
It
6B,
is also
Lordship.
government medical college, Lordship. ESF Patgaon. It is also the government.
They are part of their own board, Lordship.
No, here not
How-
mentioned.
Then you have to make allegations against the doctors. Why would
No,
they like to enlist you, throw you out of the services, unless there is a malice against you? Why should the government doctors give false reading?
Then by doctor is also government.
The doctor is there, but he's given only one reading.
Yes, Lordship. So, I would like to place on order, Lordship. Your Lordship's order.
Here one order.
WTC 6099 of 2024. Absolutely similar case, Lordship. Going on, Lordship. Paragraph. Paragraph. Paragraph 6, Lordship. The guidelines for review medical board prescribed at 7 clause 7E clearly lays down for hypertension, tachycardia.
This is exactly what is
Yes,
followed here, page number 74.
It is followed, Lordship, but they have not indicated whether it is of transient nature or not, or whether it is due to
What
excitement.
transient nature? You see the markings here on 28, at several instances, different timings it was measured, it was found to be high. 29 also, it was found to be high.
That is their lordship. We are only praying for another review, another medical examination. We are not
Already
taking-
appointment
unless-
is, this recruitment process is complete, Lordship.
Unless you have a good reason to have the matter remanded back, not like to intervene. Where is that? Just one instance of a civilian doctor giving it.
Instances also. One instance is that it's not a government medical college. Second is,
It is
they
not a
have not
government,
indicated
but it
lordship.
is not a government in that sense of the matter. But this is the hospital which will have to examine you even after you are appointed for all times.
Government as per 6 is government medical, 6D is government medical college.
The government medical college, BSF.
Also, we accepted government medical college,
No,
but then there is no indication as to whether it is of transient nature or not. That is very much.
No, transient nature means, are you suggesting that you have to be in house for 15 days or 1 month? No. Not necessary. It needs to be seen as to whether during the examination undertaken, your defect, the blood pressure was found to be high, or they have given an indication. On the day of the examination, there subsequently it may not be there. So many there, but this particular examination is objective. The idea is to these are what the rules say, that if you are not found to be within the parameters, dismiss.
That's it.
Pass orders.
All right.
Yes, right.
43 my lord. 42 and 43 my lord.
Last,
Yes.
That senior counsel AR Punya my lord, he left the court due to some ill health problem. So matter may come next week. 42 and 43.
last occasion, Lordship,
Why do lawyers have ill health after 4 o'clock? Why? Lawyers have ill health after 4 o'clock. Particularly.
last occasion, Lordship,
Yes.
directed to produce an instruction regarding Lordship, a reason,
There is a prayer made that matter be called up in the presence of the arguing counsel. It is submitted that the arguing counsel, Mr. A.R. Bhuya, was taken ill, therefore had to leave court premises. The request is made to have the matter relisted again next week.
Yes, ma'am.
Next week,